Substitution petition, which is fixed for admission on 23rd of April. In the meantime, my lord, execution proceeding have been started, which will be effectuated on.
So when do you want?
Beg your pardon.
When do you want?
My lord, today at 2 p.m. my lord.
Tomorrow we will try
Tomorrow is
because
the,
we have a lot of matters today.
my lord, tomorrow is the date fixed. That's my anxiety, my lord.
You inform the trial court that one petition is pending before this court.
Or your lordship take tomorrow, my lord.
Tomorrow?
My. Obliged.
With the consent of the other side, I beg to mention item 12. It may be taken up on any other date. Lordship, my senior could not come to the court due to some personal difficulties. In this case, I am agreeing for the appellant. Lordship.
Okay. As agreed by learned advocates of both sides, justice shall list the matter on suggested date after vacation. Before vacation, not possible. Yes.
May have the lordship. My lord, this is the land dispute between two parties. So many cases have been filed by the appellant. All the cases he has lost. Now he has met his own men as parties and filed this case. So it may be listed in the next week before the appropriate bench. Obliged.
May I please, Your Lordship? My Lord, it's a regular first appeal filed on, my Lord, 18th of February, my Lord. My Lord, may I pray, my Lord, may be taken up on the Friday, my Lord, 21st of this month. After tomorrow.
Yes.
May it please, Your Lord. My Lord, this MFA was filed on 11 March, my Lord. And there is some urgency, my Lord, because the recovery proceeding has already been initiated. So, my Lord, it may be listed on Monday, my Lord.
Monday.
My Lord, 24th March.
Okay.
May I please, Lordship? So I beg to mention item number 11, Lordship, of daily list.
Yes.
Lordship, may be listed after 1 week next week.
After 1 week. Your name?
NH Lordship, Lordship.
Mr. NH Law School Learned Counsel for the petitioner. Press for listing the matter after we pair a lot.
File.
Lordship, I
Yes.
quickly mention item number 18.
When do you want?
Crossover for the day.
On the pair being made by Mr.
D. Hazarika.
Learned Counsel for the
D.
petitioner.
D. Hazarika.
Petitioner.
Appellant. Petitioner.
This is CRP.
CRP. Petitioner. Yeah.
You inform the other side?
Other side of incorporation.
Yes, sir.
When?
Other side not appeared.
No, whether you inform the other side that you are praying for adjournment
Not,
today.
not sir, lordship.
You see, name of some council is reflected in the call list. You first inform the other side. Then thereafter you mention the matter.
18. 18, lordship.
Yes, 18.
Other side name not shown. Lordship,
You inform him and thereafter come back.
May I please, Your Lord?
Yes,
I beg to mention item number 13. I have the instruction to withdraw the matter, Lordship.
13.
13, Lordship. The matter
Your
has
name?
become infructuous.
Your
S.K.
name?
Gupta. S.K. Gupta for the petition.
S.K. Gupta. Mr. S.K. Gupta, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. Where is accordingly allowed, this service that's disposed of on withdrawal.
Lordship, I have another prayer for listing of an IA civil.
When?
Any date convenient to Your Lordship.
Next week, take it that from him. Yes.
May it please, Your Lordship? Lordship, I beg to mention one CRPI of fresh matter, Lordship, for motion column tomorrow, Lordship. We have urgency in the injunction matter.
Tomorrow is a hearing day. On
Lordship.
Friday, we will try.
Lordship. And one RSA, Lordship, in orders column, Friday, Lordship. Orders column, Lordship,
Orders
for
column.
service report, Lordship.
Okay.
Obliged, Lordship.
May I please, Lordship? Lordship, I pray for listing of a civil revision petition. It is an urgent matter, Your Lordship. What has happened in this matter is that, Your Lordship, the defense witness, Your Lordship, has in his evidence and affidavit stated that there is a dispute and the genuineness. of
When,
the-
when do you want?
Your lordship, tomorrow, your lordship.
Tomorrow hearing day.
Your lordship, there is cross-examination of the defense witness fixed tomorrow, your lordship. So,
Maybe you file a petition for adjournment day.
Yes. Much obliged, your lordship.
Yes.
Wait, please, your lordship. Lordship, I beg to mention item number 25. Lordship, the conducting, Mr. SP Roy is out of station. Matter may be fixed for another.
Okay. On the pair being made by Miss
P. Agarwala.
P. Agarwal, learned counsel for the appellant. You inform the other side. You inform the other side.
Yes, Lordship, with the
With
consent.
consent from the other side, press for listing the matter after a week.
May I please, your lordship?
Pair alone.
With the consent of the adversary, I beg to mention item number 27, lordship. Lordship, we'll file the objections against the said contradiction application. Lordship, we pray for some time, lordship. For that.
You inform the
We have.
Lordship, we want a date to be fixed in the matter. Lordship, the matter last came up in June of last year. And
Lordship, after
has been
verification, any date,
this
we are
27. Item number 27.
27. I am for all the respondents, 1 to 4. So, lordship, we are filing the objections against the said
As agreed by learned advocates of both the parties, recess and list the matter after
verification.
Lordship,
vacation.
second week of April.
Lordship, it will be possible after verification.
Okay, after vacation.
Lordship. We are going to file the objections against it.
Lordship, if a date can be fixed 22nd.
Yes.
29. Much obliged, lordship.
May I please, your lordship? I have filed an IA on 10th of March, my lord, in a RSA, my lord. Can it be taken up on 5th of my lord, March, my lord? 26. Obliged.
May I please, Lordship? Lordship, item number 4 is for praying for adjournment.
Item number
4. Engaged senior counsel is out of station and he has also submitted his letter of absence. Let the matter,
is your good name.
D. Varman.
Miss D. Borman, learned counsel appearing on behalf of Mr. D.K.
petitioner.
Bordolo,
Yes.
learned conducting counsel for the petitioner, press for listing the matter after
25th or 26th March. Sorry, 28.
May it please, your lordship? Lordship, with the consent of the adversary, I beg to mention item number 32.
item number 30.
32, lordship. This matter may kindly come up after 2 weeks.
Mr.
SP, sir, my lordship.
Learned counsel appearing on behalf of Miss Hardy Moses, learned
lordship.
counsel for the opposite party with consent from the other side, press for listing the matter after
2 weeks, lordship.
after 2 weeks. There,
Obliged.
May I please, Lordship, he will not be able to appear 28 on March. Item number 4.
25th.
Yeah. May I please, Lordship, I beg to mention item number 15. Lordship, I am appearing on behalf of learned senior counsel GP Boli. Lordship, kindly adjourn the matter for today.
Item number 15.
15.
On the appearing matter, Miss, your good name, please.
R. Gaur.
Learned counsel appearing on behalf of Mr. J.P. Bom, learned conducting counsel for the appellant, recess and list the matter when?
After week.
After a week.
Obliged.
Please, your lordship. Sir, I beg to mention for listing MSc April of 2016. Well, this matter may be listed on my lord 29/4, my lord, after application.
29,
4 April,
4th April.
my lord, 29, 29, my lord. After vacation, my lord. A similar period is my lord MFA.
Yes.
Item number 18, I beg to mention.
You inform them.
Yes,
Okay. Your name, please.
D. Hazarika
D. Hazarika, learned counsel
for the petition.
for the petitioner with consent from the other side, press for listing the matter when?
2 weeks.
After 2 weeks. Okay. Here, look.
Like,
May I please, your lordship? I beg to mention item number 41. There is a defect in the IA. Matter will be come up after 1 week.
Item number
41.
21,
41.
41. You are for the
Appellant,
appellant, Mr. Your good name,
A.U.
please.
Ahmed,
Pardon?
A.U. Ahmed, Abbas U. Ahmed.
A.U. Ahmed, learned counsel for the appellant. Thanks for listening the matter after
1 week.
1 night. Here allowed.
May I please your lordship. In this case, prior to go to the, my lord, FIR, I beg to state that, my lord, after filing of this case, my lord, we could learn yesterday, my lord, evening, the charge sheet has been submitted in this case, my lord. And as on today, 40 days. Earlier, I have approached before this honorable court in an anticipatory bail petitions, and your lordship has dismissed my bail petitions and directed me to appear before the IO, my lord. And accordingly, I appeared before the IO and was arrested. And since then, today is 40 days, my lord. So may I pray for consideration of my bail? Here, my lord, because a charge sheet has been already submitted, and 3 persons has already been arrested, including the petitioners, and other are abscond.
What are the section?
Sections, my lord, kindly have a look at page number 12, my lord. This is the FIR, my lord. And sections are involved, which is in 15, my lord. 111, 61 to 288 BNS, reduced section 4 and 5 of Explosive Substance Act, my lord. I'm cooperating with the investigations after rejection of my bail prayer, anticipatory bail prayer by this honorable court, my lord. I have appeared before the IO as per directed by this honorable court. And that order also I have annexed in this case, my lord. And on appearance, I was arrested, my lord. So may I pray for
What is
consider?
the punishment for section 4 and 5 of the Explosive Substance Act?
Lord.
What is the part?
I'm sorry, I could not have the book, my lord.
Mr. Das?
4 and 5 section explosive substance.
Extended to 14 years, Lord.
14 years, my lord.
It may be extended to 14 years.
14.
14.
Now the my lord
Let
investigation.
the record come. We'll see.
No.
What materials are there against it?
From my lord Munsif, ZMFC, South Salmara. The case is now pre-committal stage at court, my lord.
Third, Mr. M.A.I. Hussain, learned counsel for the accused, and Mr. K.K. Das, learned additional respondent. The application under section 483 of the BNSS 2023 is preferred by accused Anwar Hussain alias Anwar Islam, who has been languishing in jail as in connection with Lancaster PS case number 221 of 2024. Registered under section 111 stroke 61 2 stroke 288 of the NSS. Reviewed section 4 stroke 5 of the Explosive Substance Act 1908 for grant of bail. The learned counsel for the accused submits that the accused was arrested on 8/2/2025 and he surrendered before the IO as per direction of this court. Until that, he has been languishing in jail as for last 40 days. And in the meantime, investigation has been completed and charge sheet has been submitted before the court of learned judicial magistrate first class, South Salmara, Manchester. In view of the submission of learned counsel for both the parties, it is provided that justice shall call for a scanned copy of the record from the court of learned judicial magistrate first class, South Salmara, Manchester, fixing the matter on
3rd of April.
3rd of April.
Item number 2, top of the list.
Listen letter. Lordship, we received the letter, Lordship. Herein, it has been stated that my termination has been withdrawn, Lordship. So,
Pardon?
We want to withdraw the case.
no, the termination has been withdrawn, Lordship. Now, there is a resolution referred to in that letter, Lordship. It's a resolution dated 15/2/2025, Lordship.
What do you want?
Now, if Lordship, the subsequent action taken by the authorities upon me goes, Lordship, then that would be helpful for me, Lordship. Since the main notice whereby I was terminated is already withdrawn, Lordship, I possibly don't have any grievance, Lordship, but then the subsequent actions taken against me are also there, Lordship. If that goes, Lordship,
15.
then I would be happy, Lordship.
That?
If the subsequent actions taken against me goes, Lordship,
No, can we prevent it?
no, Lordship.
They are at liberty to take any action
Since
against it.
executive body is a party, the executive committee is a party to this proceeding, Lordship, let them produce this resolution dated 15/2/25. And if Lordship sees that that has been taken care of, then automatically I get the relief, Lordship.
Oh, once the termination order is withdrawn, this matter become infractious.
Lordship, yes, it's simple in that terms, Lordship, but then they have taken action against me, cancelling the earlier termination order, Lordship. It's there.
No,
Lordship.
is it your case that they have again initiated any action against you?
No, that subsequent action also goes, Lordship. That observation, if Lordship skips, then I would be relieved, Lordship. Because on there's a report resolution dated, Lordship, 11/10/2017, whereby I was it was stated that my services won't be required with effect from 11/1/2018, Lordship. Subsequently, that development came in, Lordship. That is there in the affidavit in opposition filed by them, Lord.
10/10 termination order is withdrawn. 10/10. Okay. There are two resolutions, my lord.
So the first termination letter is at page number
It's at page number 44, Lordship.
40.
44.
Hello, there are two resolutions.
That has been withdrawn by this letter, Lordship. Page 44 has been withdrawn, Lordship.
Page 4. Exception. No. Yeah.
Then where is the other result, other letter?
Lordship, in the affidavit in opposition, internal page number 13, Lordship. Annexer B. That other termination order is not there, but there is a resolution of the executive committee, Lordship.
Annexer?
Annexer B, Lordship. petition number, আপনার উপরে minutes of meeting dated 24th October 2017, Lord. It would be
P 50. This one.
page 59,
Page 59.
Lordship. Herein the date that is with effect from 11 January 2018, Lordship will find at page 16, Lordship.
This has not been withdrawn.
This was not withdrawn.
This has not been withdrawn. Hmm.
So where is the first termination order? 10/10/2017.
Page 44, Lordship.
Hmm. Okay. Page number 50,000. This one.
So now what is your pair?
Lordship, if this goes, Lordship, the next resolution which was taken on 24th October 2017, Lordship, that is at page 15, 9. That was in consideration of a representation preferred by me against this termination order dated 10/10/2017, Lordship. They did not, Lordship, take into consideration my prayer, but they said that the termination would effect from 11 January 2018, Lordship, instead. So if this goes, Lordship, I would say that this would also go. But then what the resolution says is not the resolution whereby the termination was withdrawn is not before your Lordship. So if Lordship takes note of this and also says that this would also automatically go, then it would serve my purpose, Lordship.
Whether your senior is available, report
Sin, Lordship,
available.
yes, Lordship.
Yes, I support the senior counsel to remain present in the court.
Otherwise, Lordship, if that resolution is produced, then Lordship would come to know whether this has been taken care of or not, Lordship. That resolution dated 15 to
Okay,
2020.
we'll see the record. First, let your senior remain present.
Lordship.
At what time? 2 o'clock?
Yes.
2 o'clock.
Yes.
আর নাই বলবো এখানে আছে
May I please, Your Lordship? Lordship, on the last occasion, Lordship has posed a question on whether vision will be maintainable. I've come across a judgment, Lordship. Similar set of facts, Lordship. This judgment has also taken into consideration both the judgments passed by the Honorable Supreme Court in Sangram Singh's case as well as Arjun Singh's case, Lordship. Para 9, if your Lordship would take up on the last page, Lord. May I read it, Lordship? May I read it, Lordship?
Hmm.
This court is in complete agreement with the decisions of Honorable Allahabad High Court in Jagardev's case, Kailash Nath's case, and Aneja's case. The provisions of Order 9 Rule 7 CPC cannot be taken given narrow construction to say that defendants can move an application under Order 9 Rule 7 CPC only on the next date of hearing and not beyond that. Such an application can be moved at any stage till such time the arguments have not been heard and judgment has not been reserved or ex parte judgment has not been delivered. In that case, only recourse will be to move an application under Order 9 Rule 13 CPC and not under Order 9 Rule 7 CPC. In the instant case, Lordship, the suit is in a very preliminary stage. Evidence has not been filed by either of the parties. So in that case, Lordship, we cannot, we are not against a decree. We are against an order, Lordship. So no other remedy remains other than filing an application under Order 9 Rule 7, which is not an applicable order, Lordship.
There is a judgment of Supreme Court. A recent judgment in the year 2023 or 24.
Lordship, the landmark judgment was Sangram Singh's judgment, which, Lordship, I have a copy of. Lordship, in this case also, the learned court ultimately allowed the revision petition, holding that the application under Order 9 Rule 7 is maintainable. This is a recent judgment, Lordship, of 2015 Uttaranchal High Court. This judgment is also a recent judgment, Lordship, and this is also
of 2015.
15, yes, Lordship. This is taken into
The Supreme
consideration.
Court decision is of 2023 or 24, like that.
Because Lordship, in Supreme Court, Lordship has clearly cited that when arguments are complete in a suit and when the matter is reserved for passing a judgment, in that stage, Lordship, Order 9 Rule 7 petition will not be maintainable. But if the suit is in preliminary stages, then Order 9 Rule 7 will be maintainable, Lord. And against that, only revision can lie. Because there is not a decree, Lordship.
Okay, we'll see. We'll keep the order result. Part, Mr. Your good name, please.
D. Mazumdar, Lordship.
D. Mazumdar, learned counsel for the petitioner.
Lordship, the matter is fixed for evidence tomorrow, Lordship, that is 20th of March.
Maybe you filed a petition there or that. Argument conflicted order is that we reserve the order.
Much obliged, Lordship.
Item 5.
May I please, Your Lordship? Lordship, petitioner before your Lordship filed a petition under Order 22 Rule 3 with a prayer to, Lordship, with a prayer to substitute the name of the legal heir of the deceased Lordship plaintiff. That was not considered. Then they filed a petition under.
Where is the order? Impugn order?
Lordship, that is, Lordship, kindly have a look at page 42.
40.
Lordship, 42, Annexure 4.
44.
42, Lordship, start from 42. May I read, Lordship? By this order, I am about to dispose of petition number such and such. No written objection filed against the said petition by the defendant side. Also, by order dated 25/7/2024, defendant verbally submitted that they have no objection regarding the above mentioned petition. Here I am about to dispose of the same on basis of the merit. This petition under such and such filed by the petitioner under order such and such with section 151 and under order 6/17, section 5 of the Limitation Act for condoning the delay in filing the
So
instant.
that petition was allowed.
Not allowed.
71 was allowed.
Lordship 71 dismissed and 251 allowed. Two petition filed, two plaintiff expired. Plaintiff number 1 and 2. In respect to plaintiff number 2, their their petition allowed. 1 was not allowed.
71 was not allowed.
Not allowed. Lordship,
This is
Lordship,
for
it is
condonation of
party
delay.
portion of the order 45, Lordship.
No, 71 relates to condonation of delay.
As well as Lordship substitution. And there, under so many provision, it was filed, Lordship. 22(3),
Where is that petition? 71?
Lordship. Lordship, it is
Page number?
Lordship, it is annexure 3, page 32.
Yes.
Page 32. Thirty-two onward, Lordship. Page 33, Lordship. A petition of the petitioner above named under order 22, rule 3, read with section 151 CPC and also under order 6, rule 17 and section 5 of the Limitation Act.
What is the number?
Number? Lordship, it is the number was not. Only the title suit number was there, Lordship.
The petition number.
Number was not there. Number was not reflected, Lordship, in the copy. Only title suit number was reflected. Original copy, Lordship. Lordship, it is certified copy. Lordship, kindly have a look at page 36, annexure 3. Annexure. It is the certified copy, Lordship, of the petition. Number was not given, only suit number was given.
No, number is there.
Lordship, page
That 71.
Lordship, page 36. Page 36, it is not.
Annexure 3.
Lordship.
Yes.
Number was not.
You have not seen the number. Left side top.
Yes, Lordship. But it was in the type, it is not. It is there in the left side, Lordship. 71.
So this type copy is page number?
Page number, Lordship, 32.
Page number?
32 onward, 32, 33.
Mazumdar, let notice go at this step.
Lot.
Third, Mr. L.R. Mazumdar, learned counsel for the petition. This petition under Article 227 of the Constitution of India, read in Section 151 of the Code of Civil Procedure, is referred by the petitioner. Eight petitioners. There are 8 petitioners.
The sample,
How many petitioners are there?
Lordship, there are 5, 6, Lordship. Lordship, up to G. 8,
8 petitioners.
Lordship.
Eight petitioners.
Total 8, Lordship. 8.
8 petitioners have silenced the correctness or otherwise of the order dated 1/2/2025 passed by the Lorded Civil Judge, Junior Division number 3, Kasar Silsor, in Miss Case number 155 of 2024, filed under Order 47, Rule 1 CPC, dated Section 151 CPC. For review of the order dated 3/8/2024 passed by the learned court against the petition number 71 of 71/01, and also the order dated 3/8/2024 in petition number 71/01 filed by the petitioner under Order 22, Rule 3, Graded Section 151 of the CPC, and also under Order 6, Rule 17, and Section 5 of the Limitation Act, by which the learned trial court has rejected the pair made by the petitioner. Whereas the petition and the documents present record, let notice be issued to the respondents returnable in 4 weeks, step be taken by registered post with AD and also by usual process within a week from today. Release the matter after 4 weeks.
Lordship, interim may consider, otherwise there is a next date for argument, Lordship.
Pardon? At what it says the case is pending now.
Lordship,
At what it says the case is pending.
Lordship, at the stage of argument, Lordship.
Argument.
Argument.
So till returnable that further proceeding of titles of numbers so stand state.
Of like.
Supplementary case item number 42.
My lord, I have just entered appearance by filing in a work power from my junior yesterday. Lordship may have a look at your lordship's order, last order, 12/3. Copy of the same. This is the matter of 19/3 as part of, on that day endeavor shall be made finally here, dispose of this petition. The idea to dispose of is good, my lord, but I'm respondent number 9. It will not be good if it is disposed of without me. Actually, notice has not been served at me. I came to know from my principal of the college that this case has been filed and that way it is. Let a copy of the writ petition to supply to me. I don't have the writ.
After that, I'll come, my lord. First, I'll satisfy, my lord, what is the subject matter of the case is that. After issuance of the notice, my lord.
Yeah.
It will be, my lord, it will be the same mistake. If if the private respondents, without serving notice on the private respondents, the matter is hard. It is good, idea is good that the matter should be disposed of.
My lord, why I am insisting, your lordship, my lord, I prayed for an interim order, my lord, and yesterday, day before yesterday, it was fixed for the interim order, my lord. Affidavit is there, my lord, that I'll come, my lord. What is the case about, my lord? Let me place there, my lord. If your lordship find, my lord, there is a prima facie case for interim, then your lordship will grant, and as well as lordship will issue the notice, my lord. That is my case, my lord. Now lordship will see. May I start, my lord?
This order dated 12/3/2025 was passed on being agreed by the parties. It was not informed that some other private respondents are also there and notice upon them have not been served.
Notice was not issued, my lord. It was the only motion stage, my lord. Let me place my case, my lord.
Anyway, I
Then
have entered
lordship,
appearance. I have
If
entered
your
appearance.
lordship issues notice,
Meaning
then
thereby-
only they will come, my lord. Lordship has not issued notice as on date, my lord. Here, my lord, the case is that, my lord, petitioner was appointed by the governing body, my lord, which I have stated in Prabha. 15/11/2005, my lord. Lordship kindly note down that. At page 38. I was appointed and law says, my lord, NAT or select has to be there, my lord. So I cleared my select on 26 February 2014 at page 42. Lordship has come across page 42. And NAT I have cleared, my lord, at page 44, 21/4/14. I got NAT also, select also. Thereafter, my lord,
Sir, for we are let notice go at this instance. Let
my
us
lord,
file a-
question of interim, my service has been removed.
This is packed together. Actually, it's a composite order. When the matter was filed, I was only for my provincialization, not against others. Now, as per the single judge's order, I was provincialized. It was none of my business that after giving her a so-called notice, she was her provincialization. That is different thing. Cannot be intermingled in this case, so far as I am concerned, my lord. So I will also, there will be some technical problem. Let me tell you, lordship. Suppose everything has been done as per the learned single judge's order, rightly or wrongly. If her removal is also as per learned single judge's order, my provincialization of, then the observations and the findings of the learned single judge cannot be interfered or, my lord, altered by another single judge by your lordship. Bench appropriate forum would have been
Division.
And I think there were moments when she had enough time to file a review petition, my lord, when coming to know. Our case is that she was not implicated in the first case. Not implicated because no grievance. First case was simply for mandamus for my provincialization, and the learned single just passed and wrote many things there. So let a notice, and I will produce, and it will only appropriate to tag it together with civil rule number 4041. All pleadings are there. And there was also a contempt proceeding pursuant to which. Now, any interim order at this stage will make a mess of whole thing. So, if she is restored, she will be restored.
See, my lord, I was working, I was provincialized.
Everything is right.
Neither
Everything can
my-
be restored by your
Let me
lordship.
make.
I am
my
not against
submission,
her
my lord.
working.
Let him finish, my lord, then I'll continue. My.
I am not against her working. In my original petition was also there. But the technical problem I am telling your lordship. I still believe there were opportune moments for her to come if she is also against my provincialization in that case. And I'll bring in all the documents and the pleadings. So give a notice, posted that if she is reinstated, she will be reinstated to their benefit. Court has always got the power, but there are many things involved like this. And disposing it finally, and since I have appealed, the most essential, my lord.
My lord, they are not the cabinet,
party
they are
respondent.
nothing, my lord, wasting of the
Maybe
valuable time of the honorable court,
Comment
my
is
lord.
there.
Let me place my case, my lord. If your lordship find prima
No,
facie case, my lord.
No, Mr. Borbuya, she is a party here.
Yes, both are party, my lord. There was a suppression of the facts, my lord. Let me place before your lordship, my lord. Hardly I'll take 2 minutes time, my lord.
Hmm.
Your lordship hear me, my lord. Either your lordship grant me interim or not interim. That is altogether different, my lord. At this juncture, my lord, notice has not been issued. They no, my lord, by filing ukalatnama, they cannot argue, my lord, as a respondent. The only service part is complete for them, my lord. Yeah, my lord, your lordship will issue notice, then only they will come, then their question will come, my lord. Yeah, my lord, today is the date fixed for the consideration of the interim order. Now lordship will see what is the substitution of the fact.
Today is the date for endeavor to make final disposal.
My lord, before
That was
that,
the
my
earlier
lord,
question.
order has been passed by
Interim order
the,
was not considered by your lordship on 12.3. Lordship said, list the matter for final disposal by making an interview. Let us not intermingle consecutive.
Honorable Justice Michael, my lord, he has fixed the matter for interim consideration. Then, my lord, matter was listed before your lordship. Your lordship heard the matter. Then, your lordship decided to dispose of the matter today itself. Now, lordship, let me place my case, my lord, in a very short while, my lord.
No,
That-
Mr. Borbuya, you see, the party entered appearance.
Entered appearance without issuance
without,
of the notice. That
without-
part also lordship has to
no.
examine.
Without
Without
affording an
issuance of notice.
opportunity of being heard. I think it would be improper to pass any order.
My lord, lordship will see, I was the
Mr.
working
Borbuya,
teacher.
Borbuya, furnish a copy to them. Let them file their affidavit. We'll fix a very short.
My lord, in that case, my lord, my lord, my bread has been snatched away by the wrong interpretation of the order. Honorable single judge never said you remove me. And I am not a party to that proceeding. Lordship, for a moment, my lord, lordship will be satisfied, my lord, how suppression of the fact came into picture. Lordship kindly turn to page 10, my lord. Lordship kindly turn, my lord. Serial number 5, my lord. Actually, the whole problem creator is that one. They need to have challenged her appointment. Lordship, kindly have a look. Karavi Gogoi. Lordship has seen last page. And date of appointment is 2011-08. Net and select, my lord, has been before and after joining. That time, as per the amendment law, my lord, 7 years was needed. And she does not have 7 years. But that part, my lord, government is totally silent. Lordship, kindly have a look, the notification during that time. 7 years. And how, my lord, that person was provincialized as the serial number 3. 7 years, she does not have, my lord, lordship, kindly count. Lordship has seen, my lord. The main game starts from there. Similarly, my lord, before passing NET, I have passed out in month of February. Accordingly, my service was provincialized. That your lordship will see page 45. My service was provincialized. There on their agitation, it was been withdrawn temporarily. I filed a writ petition. Then they said I have revoked. Then again, my lord, I have to approach honorable court now, my lord. The impugn order, the speaking order, honorable single judge lordship has seen on the last date, my lord, last 2 lines, my lord, is a very much clear. The adverse order shall not be affected the person while considering the case of the private respondent number 9. But wrong interpretation and to cover up their liability from the contempt proceeding, they said we have acted. That is the case. And I was provincialized teacher. How come, my lord, under what authority of law, merely giving me notice and has been withdrawn, my appointment was illegal, or I do not have the length of qualification? 7 years is the mandatory. And prior to her, I have clarified NAT also, SLAC also, February and April, my lord, 2 decades. Both way I am qualified. Better than also, even my lord Karavi Gagai, she is also respondent. Before completion of 7 years, how come my lord her case was considered for provincialization? That created the havoc. She completed only 5.5 years. To that part, government is totally silent. And in the read petition also, though my learned senior friend has filed, that point was not brought to the knowledge of the court. That is,
No.
that is,
That
let
lies
me
the
complete.
problem. That was
Let
brought
me
to the
complete.
knowledge of the court.
Let
That
me
lies,
complete.
no, Korobi Gogo is a different department,
I'll
not
just let,
Assamese, elective person.
let
There
me
lies the
complete,
problem.
my lord.
That's why I say let that matter and all the documents contained.
Oh,
there.
my lord, I am not permitted to submit my case, my lord. What is the decorum, my lord? Being as designated senior, my
No,
lord.
you are saying that there is suppression of fact.
Suppression of
Korobi.
fact, my lord,
This is
that is
Korobi.
on the record.
No, this is Korobi. This is also from record. This is Korobi. She is.
Okay, Mr. Barbara, let him complete.
Yes, my lord.
I will give
I'll
you
not
some,
continue if your lordship thinks.
please.
Then lordship will see Karavi Gogoi is the SMS, my lord. Elective is the part of this, my lord. There is no specified subject as per law that elective or non-elective. Subject is SMS. Then your lordship kindly turn to page 10, my lord, where I was on the last day, my lord. Karavi Gogoi. Provincialization on 26/5/14. Now lordship kindly count her length of service. 5 years, some months. And law says 7 years. That part is suppressed by the department as well as by the other writ petition. They ought to have hesitated particular this post. Because that is totally on the face of record, it is totally illegal. She does not have qualification. And lordship will see nowhere mention the act of 2013 which was brought, amended, which I have supplied to your lordship. And instruction also does not say so. On the last occasion, your lordship was pleased to direct the government to supply me the copy of the instruction. I have gone through it and nowhere mentioned, my lord. How come, my lord, that Karabi Gagai came into picture premature of just completion of 5 years, some months? Law does not permit. Without making victim to that defaulter person, and my provincialization has been cancelled or withdrawn by the impugn order. That cannot be, my lord. Now, lordship will see when she has completed her need, my lord. The private respondent represented by my learned senior, my lord. That I have annexed already, my lord. Law point also I have annexed, my lord. Because my service was provincialization by virtue of earlier act, my lord, which has been repealed subsequently in the year 2015. Now, lordship will see when she completed. What this I want? Argument. Para? Lordship kindly see para 21 at page 29. May I read, my lord? Small paragraph. That it is a subtle rule of law that once the bread is provided to a person in conformity of the law cannot be snatched back and to provide to someone else at the cost of the holder of the bread. In the instant case, the petitioner was provincialized by the order dated 26/15, wherein nowhere direction was issued to remove the petitioner. That is the earlier round of litigation filed by the private respondent. Petitioner but the respondent number 456 has misinterpretation of the order of the Honorable Court, Annex 6, wherein where direction was issued to remove the petitioner at all, but the respondent number 6 on his own motion passed the impugn speaking order, which is not sustainable in the eye of law. Rather, it can be revealed the impugn speaking order passed in a very harsh manner and nowhere provided any justification issuance of the impugn order. In as much as the service jurisprudence is very much protective for the petitioner, that is the private respondent number 9, who had obtained any need in the month of November after me, my lord. I have obtained in the month of February, she obtained in the month of November. In the month of November, February, select so and so. And in the month of April, that is me, my lord. Much better than the private respondent. Similarly, the respondent number 10, who completed NEET, but no completed 7 years and 10 years. 10 years is the 2012 Act says, and simultaneously it was been amended, which I have given by notification. 7 years of service as per the Act of 2011, as amended 2012 and 13. Over and above, respondent number over and above new law came into force in the year 2018. In the same act, petitioner is also entitled for regulation of the but the impugn speaking order of the director higher secondary could not justify for the issuance and withdrawal of my provincialization very mechanically and tactfully issued the impugn order liable to be discarded by. Now, my lord, the question comes before your lordship, two things. I passed my NEET before her. Simultaneously, my lord, the private respondent, other respondent whose service was provincialized in the year 2014, she did not complete 7 years or 10 years. Some 5 years, some months, if you count from that, my lord, page 10, which I have referred. So, without targeting that particular post, my lord, the official director has issued the impugn termination order against me. And I have been already regularized, page 45 BC in my lord. Once I have been regularized, my lord, does he has the power to revoke it, my lord, just like that, to accommodate some party? Page 45 BC in my lord. And type copy is, 20 June 2015. My service was provincialized. I received some months of salary also thereafter, my lord. By virtue of the speaking order, page 87, my provincialization has been nullified. So at this juncture, my lord, the impugn order has to be stayed, my lord. It is not the case, my lord, I'll be without food and she will be with food. That is not the law. For making balance, my lord, lordship have to stay, my lord, the impugn order, then let them file, my lord, whatsoever they want. That is my case. And I asked for the also, my lord, in the writ petition prayer portion to cause a departmental inquiry by respondent number 1, my lord, as to how, my lord, the irregularities has been occurred. And I became a soft target.
Yes, Mr. Barbara.
Now, let us see what impugn order he wants a stay. Without the copy of the writ petition, I'm saying, the stay order he wants is not only a stay of his client's removal, but also a stay of provincialization of me. I have already joined in service. And it has been pursuant to the learned single judges. He wants a stay order of Annexer 1516. Kindly have a look how this order was passed at page 87, Annexer 16 of the order. He is simply, indirectly, he is asking for a stay of Annexer 16 and 17. Indirectly asking for the basic order of Annexer 17, which he has impugned. His decision is speaking order passed pursuant to learned single judge's order. Whether learned single judge was right or wrong is a different thing altogether. And there was a contempt file for not provincializing me, and consecutive courts asked the government, why are you not provincializing this lady? At the threshold, I said, I am not against the provincialization of anybody else. I said for long, in spite of fulfilling all eligibilities, I have not been provincialized. Kindly have a look at Annexure 16. This is a composite order. If government has created some mess, it will create further mess. Any interim order at this stage, that's what I am submitting, without being given an opportunity, as he said. Annexure 16 said this is a speaking order. Kindly have, Lordship had to read it for a while. Annexure 16 at page 87 of the writ petition. That the Honorable High Court order dated so and so passed in WPC number, wherein the Honorable Court has directed the operative portion of paragraph 12 of the judgment is quoted. Accordingly, irrespective of the aspect whether 4 posts would be available for provincializing the service of the assistant professors in the Department of Assamese in so and so college after amendment of 2017, or whether still 3 posts would be available, the respondent being the Director of Higher Education to pass a consensual order for provincialization of the petitioner in terms of Act 17 within a period of 4 weeks from the date of receipt. Now, this is important. If in doing so, the director is required to pass any further order which may have adverse consequence as regards any other assistant professors, not only her, any other assistant professor, may do so by following due procedure of law by giving appropriate notice to such person who may be affected. It is not said that particularly this petitioner, any other in the college, while provincializing me and judging that who joined the service first, etc., many considerations, the learned single just passed this order. If 4 posts are available and there are 4 assistant professors in the subject of Assamese as per the teaching, and are available, and there are 4 assistant professors in the subject of Assamese. I showed in the, there are readings to show that the one lady who is working in the Assamese, that is actually elected Assamese, a separate department as per guidelines of the Dibrugarh University. This learned single just considered all these things. And government advocate submitted that without disturbing, there are 4 posts, 4 can be regularized. That's why that file will be important, or any order whatsoever. If 4 posts are available, there are 4 assistant professors as per teaching, non-teaching staff pattern as per principal. No reason for any adverse order to be required against anybody else for provincial in service of the petition, if the principal finds. And if the director finds, and if the director says that for provincializing me, such person who may be affected, due opportunity should be given to him. Then come to the next paragraph. Peruse the speaking order so and so dated, whereby the Director of Higher Education disposed of the representation of the petitioner as, whereas the matter of provincial service of the petitioner has been examined as per provision of the Education Act, as per provision Act, number of posts, the 4 number of posts eligible for any particular subject. Whereas the services of 4 incumbents have already been provincialized in the Assamese department at Hari, and the petitioner service found access in Department of Assamese at Hari College for province. The speaking order available on record is not issued in terms. Then, whereas Odinita Burua, principal, Hari College called for hearing, I was also called for hearing. Whereas under the Assam Venture College, so and so, so and so, so and so. Then, skipping 2 paragraphs.
No, Mr. Barbara.
She was given a show cause.
No, Mr. Barbara.
Lordship.
On the other day, the Standing Council for the Higher Education Department informed the court 1 post are still lying vacant.
No.
No, on the other day, council submitted.
Right.
I have put it with specific query.
I prayed for that. I'll take it. Therefore, that I have it also that all 4 posts are.
Who appeared on the other day? Mr. Upamanyu appeared, perhaps.
I paid for time to obtain for that.
So everything has been done, at least my provincialization, as per learned single judge. My provincialization. I was not after anybody's provincialization. But if this order is my lord, now any interfered with, then my provincial license will also be interfered. That will not be proper, my lord. And moreover, as I said, there might have been occasion where the affected petitioner, this petitioner, would have filed a review against the learned single judge's order. Could have filed. I will respond to all these things. I will respond to all these things. Because sitting singly, my lord, your lordship cannot interfere, even if the findings are wrong. Learned single judge. And it has been passed pursuant to the learned single judge, at least my provincial. I am talking about my provincial. Now, this any interim order means I have already completed 1.5 months. Again, I will be out. That will also not be good. Therefore, discuss the matter. We should go, if necessary, for the interest of justice. Hear all the sides, take the pleadings, take this matter with the other, and then decide. Then, if she is reinstated, then she will be reinstated. But not by an interim order, where again, my lord, it will be creating a mess. That is my submission. Now it is absolutely for your lordship.
Lordship will see, my lord.
It was done as per learned single judge's order. my
Honorable
provincial
single judge, my lord, I am reading again, my lord, the last part, my lord, what the honorable single judge has said. I don't understand, my lord, whether this language could be understood by the department as well as by the private respondent.
Before anything, I think it
May I
is
read,
only
my lord?
appropriate to give me a copy of
May I
the
read-
petition.
May I
have
read, my
borrowed
lord?
a copy from him. Right
Yes,
now.
yes, lordship, issue notice, I'll take steps, my lord. At this juncture, he doesn't have locus also. My lord will see. Page 51, last 4 lines, my lord. If 4 posts are available, there are 4 assistant teacher in the subject of SMS as per the teaching and non-teaching staff pattern as provided by the principal. We even see no reason for any adverse order to be required against anybody else for provincialization service of the petitioner, meaning thereby private respondent number 9. While doing so, my lord, no adverse order shall be passed. And how come, my lord, the impugn speaking order, my lord, my provincialization at page 45, my lord, has been withdrawn? And I am not a party in the case. And there is a suppression of the fact that teaching number 3, how come she was accommodated before completion of 7 years and 10 years as per earlier law? So at this juncture, my lord, let the matter be stayed. Neither party will get benefit. Me also, not she also. That part, my lord, lordship will fix any other day, any issue.
Finally, hear the matter.
My lord, until and unless, my lord,
let them
my
finally-
bread has been, my lord, suppose examine, my lord. I have been given a plate of rice that has been taken away by somebody else without following due process of law. In that case, lordship will not allow, my lord.
No, we'll see. We'll fix a,
Lordship, some protection needed to be given, my lord.
We'll see,
Otherwise,
we'll
my lord, my service was already provincialization. I was doing, I have NEET, and amongst, my lord, 3 of us, I am the best person having 2 degrees. NET also, select also before that. Even though, my lord,
Mr. Barbuya will hear all the parties. Only thereafter will pass out.
so at least,
Today-
my lord,
today
at
we'll-
least, my lord, at
Sir.
least, my lord, one thing lordship can give, no salary has to be given to the private respondent.
No,
who has-
that cannot be.
Who has taken away my provincialization? Otherwise, lordship, it will take on, because on the next day,
No. In the event of setting aside the speaking order, you will get everything.
my lord, some benefit has to be given, my lord. I am having 2 degree, my lord. Question of my lord.
For filing their affidavit.
And in the meantime, my lord, let the direction be issued to the director. How come, my lord? The
We'll see it. That will
That
be
part
at the
lordship
end of the proceeding, not at this.
lordship, I am out of fish, out of water, my lord. Neither this way, that way, my lord. I have approached your lordship.
Wait for some time. Let them file their
At least
affidavit.
some protection, my lord. I'm leaving about lordship, my lord. I'm not insisting that much, my lord. Some sort of protection, my lord. Lordship has seen, my lord, amongst 3, I am the best person. NET also, select also.
We'll examine the matter. Let them file their affidavit. Take down the hard Mr. Barbuya, learned counsel for the petitioner. Then Mr. Tawbilder for respondent number.
I am appealing for respondent number 9, my lord.
No, Tawbilder.
Yes.
4, 5, and 6.
Notice to 4.
4, 5, and 6. Then for rest of the respondent.
Number one, there is no additional chief secretary hire. So two also principal secretary hire is also not there. The post is not there. And three commissioner and secretary, that post is not there. So I am appearing for 4, 5 and 6 all are hired.
So these are unnecessary, no parties. No,
Principal secretary is there, my lord.
I am not commenting.
Additional chief secretary is also there.
Anyway, I am for 9.
And
I
commissioner
know
secretary is
about
also
myself, I
there.
am
my
for
lord.
9. I don't know about Korobi Gogoi. Somebody might notice. She should also.
Okay. It appears that file order dated 12/3/2025, the case is listed for hearing today. Hearing and to dispose of the petition today. But in the meantime, Mr. A.C. Barbara, learned senior counsel assisted by
ND.
learned
MSND.
counsel for the respondent number 9, entered appearance and submits that notice has not yet been issued to him. However, he appeared on inspection and praised for furnishing a copy of the writ petition to him, and also praised for listing the matter in the next week.
For 9, I am receiving the notice now, right now.
Okay. And for giving some time
He
to
didn't take
file
possession.
affidavit in opposition. Okay.
I'll take dusty service, my lord, both 9 and 10.
It,
No, 9 not
9
necessary.
the morning.
9 I am taking.
it also appears from the record that no notice has been issued till date. Accordingly, it is provided that let notice be issued to the respondents returnable in on, we'll fix it at suggested date.
Lordship will fix next day, next week, my lord, any day next week, because I'm very. I'll take dusty, my lord. That is my part, my lord. No lingering, no dealing practice, my
I am
lord.
not
I'll
for
go
de-
myself.
I am not for
If
delaying.
necessary, petitioner will serve the copy.
By
through-
the course of the day, he should supply a
Huh?
copy of the writ petition to my junior.
Dusty through
And of
governing.
course, my lord,
It is
notice will have to be served on 10.
25th will do.
I am nobody to submit, but for that, the proceeding will be.
Next week,
25th,
week?
my lord. 25th.
25th.
Yes. About that, more question. We'll take steps, my lord. Why is it so hurried? And my lord, we'll take the steps by through governing body, my lord. Through governing body.
Suppose today I take the notice, I will be at liberty to file some response by way of an affidavit also. That's why I am saying.
But if it hardly.
So, Mr. Borboya, let it be on 28.
Yes, sir.
28 is a Friday. 27.
Friday.
Lordship fix the matter on 27. Lordship may be load also.
But 28 then, Mr. Borboya. 28.
I'll take steps through governing body, my lord. That has to be clear. Because they may be
No,
chaos. my lord.
if you serve it by Dusty Mood,
Yes, I'll take Dusty.
You were at liberty. How
Yes,
you
yes,
serve
yes,
it?
yes, yes.
Uh,
Only some observation be given, my lord.
Since Mr. Govilder entered appearance and received notice on behalf of respondent number,
Higher education department.
Official
Higher
respondents.
Education Department, no formal notices required to be issued. However, extra requisite copy of the petition will be furnished to him during the course of the day. Mr. Borbaya, Mr. A.C. Barbara, learned senior counsel for the respondent number 9, received notice on behalf of respondent number 9, and it is provided that Mr. Borbaya shall furnish a copy of the writ
During
petition
course of
to
the day.
Mr. Barbara during the course of the day. Please the matter on notice be issued to the respondent number 10 by registered post with AD and also by usual process within 2 working days from today. Thus, the service is also permitted. List on 28.
My lord,
one more.
Suggest one thing. That is only to help the court, my lord. In this high court, my lord, there are instances, general, my lord, where disposed of case also can be tagged with the present case, my lord.
The other writ.
Yes, my lord. Therefore, again, the case will break down on this ground.
Okay.
Therefore, Roxy may tag it with 4041 of 2019. The meetings are here.
Okay.
What led the learned single as to part? Why he was not in the party? The meeting will come out.
Okay.
Old 041 of 2019, putting back at disposed of.
Okay, okay. So Order learned senior counsel for the respondent number 9 submits that the read petition number so may also be taken along with this read petition. That is accordingly allowed. This is a list the matter.
And my lord, also important is contempt civil petition number 57 of 22. Because there were also orders and direction.
Contempt.
Yeah.
Also, what is the number?
57 of 22.
Contempt is number 57 of 22.
My lord, on that day, my lord, and over some resolution be given, my lord, and over to be made to dispose of entire matter. Because, my lord, I am without
Okay,
select.
okay. In term, pair of the petitioner will be considered on that day.
Lord. Hold on.
Number 6 and 7.
Well, resume of the So that two contradictory decisions.
Yes, in the meantime, some development has taken place, my lord. Development means, my lord, your lordship has also disposed of two writ petitions and following the directions of the subsequent order, my lord. That I have got the order. Your lordship will find in the order, your lordship has given reference to the office memorandum dated 7/3/1998, and the third paragraph, my lord, also find that the subsequently the impugn order notification dated 22/10/2014 has been withdrawn, and thereafter the writ petition WPC number 6241/2015 has been passed on 16/2/2016, setting aside the, my lord, that notification 22/10/2014. That is the subsequent order, my lord. And basing on that, my lord, the lordship has disposed of this writ petition, my lord. So, my lord, either your lordship may refer the matter before the higher branch, or your lordship may also, my lord, dispose of in that line.
No, while disposing of this petition,
yes,
the earlier decision was not brought to the notice of this court. Correct.
It was not brought by the either side.
So now it is before the court. So better court, so we have to refer it to division bench.
Division bench already, my lord, in the writ appeal has also upheld the decision of this subsequent decision.
But it was disposed of as infractual.
As infractual.
As infractual. It was not upheld.
Not on
It
the.
does not interfere.
Not on merit.
On
Not
merit, it does not interfere.
Not on merit.
So it will be better to refer the full bench, my lord. The constitutional question will be there, my lord. There will be two classes of teachers among those who were appointed prior to 2012. Amongst them, there will be two classes of teachers. If, my lord, the following the subsequent judgment, the teachers have been granted, those have been granted the benefit of one advance increment, my lord, they will fall under one category. and the similarly situated teachers who have been also appointed prior to 2012. And now if they are deprived of my lord, from the benefit of on the taking the course of the earlier judgment, my lord, then there will be two class of teachers among the same class. Two categories, two divisions among the same class, my lord. Because those, for them, there was no, B.Ed was not mandatory. Even even on today also, therefore for them there was no B.Ed was not mandatory. B.Ed is also always a higher qualification for them. And out of those categories, my lord, a part of them, my lord, have been granted the benefit, either following the judgment, subsequent judgment of this honorable court and other individual judgments passed by this honorable court following the subsequent judgment. So, my lord, there will be two classes among the same class if they are deprived of.
Third, Mr. D. Purpeso, Learned Counsel for the petition. And Madam Musahari for respondent number
1 and 2, your lordship, in
1 and
item number 7, your lord. 6.
6 and 7.
6 and 7 both.
6 and
6 and 7. During the course of argument, Mr. Purpeso, Learned Counsel for the petitioner, has brought to the notice of this court two contradictory orders passed by learned single judge of this court in WBC number
3733 of
3733 of 2015 and WBC number 2641 of 2015.
6241.
41, your lord.
6241.
Yes, sir.
2015.
Yes.
2015. While in read petition number 3733 of 2015 disposed of by order dated 14/12/2015, the validity of notification dated 22nd of October 2014 was upheld. But in the subsequent writ petition being WBC number 6241 of 2015, by order dated 16/2/2016, the validity of the notification dated 22nd of October 2014 was notification dated so is was. So the order dated 16/2/2016 in WBC number 6241 of 2015 was silenced before a division bench of this court. Big read the bill number. What is the number?
336 of 2017.
Pardon?
336 of 2017.
336 of 2017. The same was not decided on merit for being infructuous, or no, by holding the same to be infructuous. And as such, there are two contradictory decisions on the same point of law. In that way of the matter, this court is of the view that the dispute ought to be settled. No, is required to be settled by a division bench of this court. Accordingly, the matter is thus referred to. No, accordingly, it is provided that residential leads the matter. No, place the matter before the Honorable Chief Justice for prosecution of a larger bench or full bench to decide the following vital referral. Case number 5-1. A list according.
Number 8 and 9.
Paper, Lordship. Better maybe pass over timing, Lordship. That's time.
Number 10.
Yeah, please, your lordship. Lordship, in item number 10, I was asked to place the updated instructions, your lordship. Because on the earlier occasion, we had written to the government, your lordship, regarding his appointment. Lordship, it is still under process, your lordship.
Earlier, several times, it took time.
Lordship, here he was, his name was in the select list due to non-retention of the post. He was not appointed, your lordship. And since then, he is not in service. So now we had written to the government because there is a post vacant in that school, your lordship. And we have asked the government whether this person can be accommodated or not. So in that view, your lordship, the government is still it's working on it, your lordship. It is under process. Verifications are going on, your lordship. So lordship,
No, expedite the matter.
Lordship, I agree, your lordship. So I had a talk with them, your lordship. So they have asked for some time, your lordship, some more time.
Third, Mr. M. Khan, learned counsel for the petitioner, and Jane Osare, learned senator from the secretary. Ms. Osare submits that she may be granted further time to obtain up-to-date inspection as the matter is being processed by the respondent authority. There is accordingly allowed principal is the matter on 2 weeks after 2 weeks. 9th of April. 9th of April.
As part
As part of.
Right.
14.
Please, your lordship. This is a statutory appeal may be admitted.
Third, Mr. P. Halder, learned counsel for the appellant. This regular first appeal is directed against the judgment and order, judgment and decree dated 2/11/2024, passed by the learned civil judge, within brackets senior division, Lakhimpur, North Lakhimpur, in title number 15 of 2020. It is to be indicated here that by the judgment and decree dated so the learned civil judge, senior division, Lakhimpur,
Dismiss the suit of the plaintiff.
dismissed. Dismissed the suit.
Appellant was the plaintiff in the title suit and
Dismissed the suit filed by the appellant. The suit filed by the appellant. Mr. Gogoi, you were appearing for
5 and 6.
5 and 6. Also hard, Mr. Gogoi, 5.
Sorry to know what.
Admit. Issue notice to the respondents returnable in 4 weeks. Step upon respondent number 1, 2, 3, 4, 5.
4 already represented by revenue department. We have
4 is the revenue department. The 5 and 6 I am appearing.
4 already represented and the standing also.
Who appeared?
And the cause list also the
Issue notice to the respondent number 120 by registered post with AD and also by usual process within a week from today. However, no formal notice is required to be issued to respondent number 4, 5, and 6. Since they are represented, since respondent number 5 and 6 are represented by Mr. Gogoi, learned government advocate, and 4 is represented by
Revenue department.
revenue department.
who entered appearance.
Standing council revenue department. Standing council.
Go ahead, please.
Lordship, I mean.
How about extradited said copy
mean-
of the petition report is put in
Lordship.
report of the day. Registrar will call for the record for the learned trial court. Leaves the matter up for weeks.
Obliged.
16. May I please, Lordship, in this case, my lord, the brief has been taken back by the client, my lord.
From you.
Yes, my lord.
Okay. Mr. Siladityo, learned counsel for the appellant, submits that the appellant has taken back the brief from him. Accordingly, it is provided that recital issue notice to the appellant and release the matter after 2 weeks. You are both?
I'm for respondent number 1,
Respondent number 1. So your good name, please?
A. Hussein.
A. Hussein.
Yes.
Learned counsel entered appearance for respondent number 1.
1.
Yes. This after 2 weeks. The name of Mr. Kiladityo be deleted from the board list.
Order, section number 17.
Now, please, your lordship. Please, your lordship. Please, your lordship. In this matter, the petitioner had a matter petition to substitution of sole respondent, your lordship. Sole respondent died, leaving behind 8 respondents, 8 legal heirs, your lordship. To substitution of 8 legal heirs in
May I please, your lordship? Lordship, service is completed. Lordship, through I publishing publication, paper publication, lordship. Upon the respondent number 6 and 7, lordship. So it may
How
be
many
searched,
respondents are
lordship.
there?
As per office note, lordship. It was filed on 9th of November 2024, lordship. It is tag in record, lordship. I number 3592. 3592. Miss case.
So already substituted.
Yes, lordship. I have substituted.
your lordship, among the 8 legal heirs, one of number 4 respondent was died, your lordship.
Yes, lordship.
Number 4.
Number 4 respondent was died on 2022. Therefore, his son, Ronak Agarwala, was made a petition. The lordship, this petition was pending, not yet listed, your lordship. That petition.
Pardon?
Actually, your lordship, respondent number 4 son has made a petition to inform the honorable court his father was died. Therefore, this petition was pending, your lordship. Not yet been listed, your lordship.
When did you file?
Your lordship, in month of February, your lordship, but clerk already, the advocate clerk not yet been listed this matter. Some difficulties. Due to some difficulties, he told me.
What difficulty?
Some, I don't know, your lordship, but he told me that
There may be some defect you rectify.
Filing number.
yes, lordship,
Filing number.
3-4 times already rectified, your lordship.
Filing number.
Does
Rectified one, your lordship.
you better to fix for an
Lordship, yours restart to verify the petition.
Yes, lordship.
Oh, that
Yes,
respondent number?
Respondent number 4, your lordship.
Oh,
This one,
You have filed your affidavit?
Yes, Lord.
When?
I am filed a affidavit on 9th of November 2024, Lord. Second record.
Heard, Mr. Your good name?
Ken Borua, Lord.
Then Borua, Lord and Counsel for the petitioner and Mr.
A Pator.
A.
A Pator on behalf of Jay Sharma.
Lord and Counsel appearing on behalf of Mr. Jay Sharma, Lord and Counsel for the respondent. Mr. Borua submits that notice upon 6 and 7, upon the respondent number 6 and 7, were served through substituted mode by paper publication. And one affidavit has also been filed. And closing, the newspapers in which the notices were published. Peruse the affidavit dated 9/12/2024, and it appears that the notice was duly published in two newspapers, one in English and one in particular English. But and as such, the notice seemed to have been served upon respondent number 667, but has been unresponded. The learned counsel for the respondent submits that respondent number 4 also suffered demise. When respondent number 4 died?
On 23/11/2022.
On 23/11/2022. And a petition is filed for substitution.
Information for provide information.
And a petition is also being filed for information, but the same has not yet been listed.
Okay, not sharp, Lord.
Accordingly, it is provided that basis shall list this matter after a week, including the petition filed by the respondent number 4, counsel for the respondent number 4. Is according. So you file a this substitution petition, that you got the information today? Okay. Okay, one I rectify for.
Number 19.
That appears to the appellant on call. However, Ms. Open learned standing counsel for respondent number
1 and 2.
1 and 2 present. Office note dated, the order of laws in my court dated 11/3/2025 indicates that no one entered appearance before the laws in my court on 11/3/2025, and it may be discernible that the appellant may not be interested to pursue the case. Taking note of the order dated 11/3/2025 of the laws in my court, and also considering the fact that the appellant remain absent and I remain unrepresented today, this court is inclined to dismiss this RSA along with IA number 585 of 2020, 591 of 2020 for non-prosecution.
Apply.
Nothing. I'm appearing on behalf of respondent number 2, Your Lordship. I have to submit the column number for others, Your Lordship. I have to communicate with
You
the
have the
other.
instruction.
Only respondent number 2 substituted. I have already submitted Okalam to my.
No, you have the instruction to appear on behalf of other respondents also.
I communicated with other respondents through the respondent number 2. All are family member, Your Lordship. They issued that they will come, Your Lordship.
Okay. Heard Mr. Hussain.
A. Mubarak.
A. Mubarak, learned counsel for the applicant stroke appellant. And Mr. Korim for respondent number
2.
Respondent number 2. You have not filed a number.
Respondent number 2 already submitted.
Mr. Korim submits that he has the instruction to appear on behalf of other respondents also, and he will be filing a development number shortly. Accordingly, it is provided that recessal leaves the matter after a week.
After 2 weeks.
10 days. After 10 days.
Oblige.
What? May I please, Your Lordship? As per the office note, Lordship, these substituted respondents, we have not taken steps. Today I have taken steps, Lordship. So can it be taken after 2 weeks, Lordship?
Okay.
Steps upon these.
Mr. S.T. Chaudhary, learned counsel for the petitioner, and Mr.
T. Bharadwaj.
E. Bharadwaj, learned counsel for respondent number.
2 months.
Respondent number
2 months.
2. Mr. Chaudhary submits that
For the substituted respondent number 1, Lordship.
he could not take step upon the substituted respondent number 1. Then he may be granted some time to take step upon him.
Today I have taken steps, Lordship.
Care is accordingly allowed. List the matter after 4 weeks. After 4 weeks. Step be taken upon the substituted respondent number 1 during the course of the day.
Oblige, Lordship.
22.
Oblige, Didi.
Please, Your Lordship, I am on behalf of Respondent Advocate M.M. Kotoki. She is out of town because of the sudden demise of her mother-in-law. Her leave of absence was already filed. Lordship kindly fix the matter after 3 weeks.
After
3 weeks.
Lordship, interim may be continued.
Heard Mr.
G. Das.
G. Das, learned counsel for the applicant, and also heard Miss
R. Kotoki on behalf of M.M. Kotoki.
for respondent number
1.
1. So as spread for by Ms. Kotoki, recital list the matter after
3 weeks.
2 weeks. After 2 weeks. Till then, interim order pass order shall continue, in which petition it was passed. Interim order
Lordship, in the IA,
136.
yes, Lordship.
Maybe Lordship. I is for substitution against the appellant number 1. And appellant number 1 expired on 28/2/23.
Yes, madam, any objection? No objection.
I am forming for the irrigation department is there. They are main party.
Oh,
Irrigation department.
who represents irrigation department?
Irrigation.
Who represents?
N Upadhyay is there, standing counsel. I am for respondent number 1 only. 6 seconds.
Is she available here?
Yes, today I have to.
Can you inform her? After some time?
Maybe to come into 23.
Wait for some time. Wait for
Yes,
some
sir.
time.
24.
Maybe, your lordship. My lord, this interlocutory application is filed, my lord, praying for condemnation of delay of 549 days, my lord, in filing the connected regular second appeal. And my learned friend has filed an objection, my lord. And the main, and that objection, my lord, he has pointed out, my lord, that instead of 549 days delay, it should have been 618. And we are misleading, but that answer is there in the second file, my lord, page number 2.
That certified copy date was excluded, my lord. Skip that part.
My lord, the days have been calculated by the registry. And after the calculation by the registry, my lord, they have instructed us that 500. Your lordship, second file, page number 2. That answer is there. Second file, my lord. Connected one.
In
R-
the
RSA.
main RSA.
RSA. Page number 2, my lord. That is the calculation made by the registry.
So far that, my lord, we prepared the objection based on the copy subclass. my lord.
This is the calculation made by the
Yes,
registry.
that 549 is correct, but they have excluded that certificate copy period. That is not in their, my lord, application. So we prepared based on the, my lord, copy subclass. Now, my lord, another point which calls for a consideration of lordship. Our objection, my lord, is in record. Paragraph 7, lordship, the kindly take.
No. First, let him submit.
Yes, ma'am.
The applicant.
My lord.
Yes.
Then, my lord.
What is the reason for delay?
This part, my lord, yes, my lord. The reason for, my lord, delay, we have, my lord, explained at paragraph 8, my lord. Paragraph 8, page 4, my lord. Below, my lord.
Paragraph number?
Paragraph 8.
Yes.
My lord. That the humble applicants appellant beg to state and submitted after passing of the aforesaid judgment and decree dated 38/2017 by C.S. Sorma Lanet Civil Judge Korimgun, entitled appeal number so and so. The engaged lawyer in the lower appellate court obtained the certified copy of the said judgment and decree through a clerk of the said court and kept the same in his custody and did not hand over to any of the appellants for long. The applicant number 4, 5, and 6 are illiterate, married women, my lord, and they are ignorant about the developments and fate with regard to their suite. The applicant number 7 is a poor old man aged about 80 years, who cannot move properly and was unknown to the judgment and decree as it was dealt with by the applicant number 1 only. The applicants number 2 and 3 are daily wage earners, living from heart to mouth and quite illiterate. The applicant number 1 was dealing with the pending suit. But as luck would have it, being a day laborer and extremely poor, had to go to Bengaluru, South India for manual works for livelihood. During this time, when the judgment and decree of the title appeal was passed, the said applicant, that is appellant number 1, was far away in Bengaluru for earning livelihood. The entire suite related matters were dealt with and are dealt with by the applicant number 1. Thereafter, the applicant number 1, after learning about the said judgment and decree, managed the prospective expenses for filing the appeal by hard labor, working as a manual worker, and came back home, received the said certified copy and other connected records pertaining the suit and handed over the same to the counsel for preparing the second appeal in this honorable court. After having learned the judgment and decree, the applicant number 1 earned the prospective expenses for filing the present suit, and in this manner, there is a delay of 549 days in filing this RSA in this honorable court, my lord. This, my lord, our explanation, my lord. My humble prayer, my lord, this delay may kindly be condoned. The case will be decided on merits, my lord. And moreover, my lord, this is a family matter, my lord. There was, my lord, process of compromise. The applicants are the own, my lord, nephews of the respondent. That the applicant father and the respondent are own brothers, younger brother and older brother. The local people, leading citizens were trying, my lord, to, my lord, resolve the family dispute, my lord. And that also, my lord, I have stated in paragraph 7, most probably, my lord.
No, that can be resolved without filing the appeal also.
My lord.
Instructions I do not have, my lord.
Mainly,
Settlement.
mainly, my lord, whatever I have stated at paragraph 8, my lord, what I have proved before a lordship, my lord. That is the reason for which the, my lord,
Then,
there is a
Mr. Sodhore, why there is objection?
Objection is there because firstly, my lord, there is a 549 days of delay. Now, another aspect, lordship will kindly consider at page 15, my lord, we have stated. They took, my lord, almost 4 years for filing the conducted interlocutory application. That is almost 1,413 days. Lordship may kindly consider, my lord. That is also shows the negligent, my lord, who are the conducting the case, my lord. And there is no such explanation. Why that delay has been given 4 years, my lord, that to file this condonation application. Apart from that, filing of the RSA, my lord, with the delay of 549 days. So it is almost 5 years, my lord, and not 6 years, my lord, if I'm not wrong. Page 15, lordship, we have submitted regarding that delay, my lord. That, just below that table showing the calculation, my lord, his father's side. Lordship has got it down. I don't submitted, my lord. This ought to have been explained by the by the parties, my lord. Why they took so much of time, my lord, 4 years. The appeal was 2019, my lord, and this IA was filed on 2023, my lord. It was filed on 23/06/2023, my lord. But there is no such explanation, my lord, by this IA, why there was delay in filing the connected interlocutory application. That respect, lordship, you kindly consider, my lord.
My lord, here in this IA, we have to explain, my lord, the cause of delay in of filing the regular second appeal, my lord. We are not, my lord, to explain why this interlocutory application is being delayed. We had already filed the regular second appeal, and in filing that particular second appeal, there was 549 days, my lord.
Admittedly, you have not filed the interlocutory application along with the appeal.
My lord, that is correct, my lord. That is correct, my lord.
We filed the RSA along with the condonation application, my lord. Even if, my lord, it later said on there is some delay, then also it can be found, my lord, after 10 or say, my lord, 1 month. But here they have filed it after 4 years, my lord. Perhaps, my lord, 3 years, 9 months. I have roughly calculated. So that is also another aspect which lordship kindly consider.
Usually, we consider the period of delay in filing the appeal.
Yes,
my lord.
Usually. And usually, appeal is always accompanied by the interlocutory application for
normally.
But in this case, it is not mobile.
My humble prayer before lordship, my lord, that this IMA kindly be considered. The matter will be decided on merit, my lord. My humble prayer before lordship. This delay may kindly be condoned, and the connected appeal may kindly be allowed for listing, my lord. So considering that, my lord, this is a family dispute between two brothers, my lord. This may kindly be considered, my lord. This is my humble prayer before lordship.
This 549 days delay in filing the interlocutory application.
No, my lord, that's regular.
RSA.
Second. And for condoning the delay, my lord, After 4 years, they come up with the connected intelligence.
That is different. The RSA was filed after 449,
549 days.
549 days.
In the paragraph number, it's some sort of explanations are there.
Explanation regards delay in my lord filing the second appeal. It is there, my lord. They have stated that advocate was not handing over the document, my lord. He is not a party here also, my lord. I cannot say that is a correct explanation or not. This my lord stated very at the very first few lines that advocates hold up the records, my lord. So there was some detail.
It may happen sometime.
Yes, my lord.
These things
It
happen.
may happen sometime.
Normally, it does.
Always happens, my lord. We have been facing that problems, my lord, because of different reasons, my lord, that cannot be explained always.
Heard, Mr.
A.R. Talukdar.
Learned counsel for the applicant and Mr. Chaudhary for respondent. This interlocutory application under section 5 of the Limitation Act is deferred for condonation of delay of
549.
49 days in filing the connected regular second appeal. The learned counsel for the applicant submits that while the judgment was pronounced by the learned first appellate court on which date it was pronounced?
38, 2017.
38, 2027.
2017, my lord.
Yes, 2017.
No.
The appeal, the regular second appeal was filed on. When the appeal was filed?
My lord.
That is filed on 9/8/2019 now.
9/8/2019. And the delay of 549 days has been explained in the paragraph number 8 of the application. Mr. Talukdar further submits that the applicant number 4, 5, and 6 are deleted married women, and they were not aware of the outcome of the appeal.
My lord.
And that applicant number 7 is a poor old man of about 80 years.
My lord.
And he even cannot move properly. And he was also not aware of the outcome of the appeal being filed before the learned first appellate court. And that the applicant number 1
My lord.
is a daily wage earner, and he left for Bangalore
My lord.
for his livelihood. And applicant number 20 are also daily wage earner,
My lord.
and they are also living hand to mouth and they are quite illiterate. And that the engaged counsel of the applicants had also not informed about the outcome of the appeal and handed over the file to the applicant. And therefore, they could not approach this court by filing the appeal in appropriate time. Now, within the stipulated period, and that the delay is not intentional and rather it is circumstantial, and he has a arguable case, and as such, the delay may be condoned and appeal may be heard on merit. And therefore, it is contended to allow the petition. On the other hand, the Chaudhary learned counsel for the respondent submits that the interlocutory application for condonation of delay of 549 days, 49 days in filing the regular second appeal was filed after 3 years of
3 years, 9 months.
3 years, 9 months of filing the regular second appeal. And there is no explanation to that effect, though some explanation has been offered in paragraph number 8 of the application for delay of 549 days. Mr. Chaudhary further submits that though some averments have been made against the conducting council, the said council is not a party before this court, and as such, the veracity of the aforesaid averment cannot be ascertained in this application. And under such circumstances, Mr. Chaudhary submits that the application may be dismissed. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed on record, and also produce the statement and averment made in the paragraph number 8 of the application. And taking note of the submission of learned counsel for both the parties, and also taking note of the explanations of forthcoming for delay of 549 days in filing the connected regular second appeal. This court is of the view that the delay of 549 days in filing the connected regular second appeal is sufficiently explained. And accordingly, this court is inclined to allow this petition. The delay of 549 days in filing the connected regular second appeal stands condoned. In view of the order passed in I number 22, now the registry will register the appeal and list the same before this court, before the court as soon as practical.
Number 26. Memo copy will be filed.
I know, please.
Memo copy will be furnished. Memo copy, memo of appeal.
Not furnished.
Not furnished. Only the IAS.
So already learned counsel for the respondent opposite party submits that the memo of appeal has not been furnished to him. Mr. Talukar submits that he will furnish a copy of the same during the course of the day.
Obliged, madam.
Next, ma'am.
My lord, I'm sorry, my lord, regarding item number 19, I missed the item, my lord. The lordship dismissed for non-prosecution. My lord, earlier it was dismissed for default and I filed petition for restoration. Accordingly, I took steps. That the respondents were as many as 13. Out of that, my lord, only 7 and 10, they did not receive notice. Again, I took steps on 4, 10, 24, my lord. But as per office note, it has seen that insufficient address. So, my lord, I may be again allowed to take steps only within 2 days, my lord. That may kindly be vacated, lordship.
So, madam, you have not appeared before the Lozingma court also.
My lord, I was out of station, my lord. That's why, my lord. Due to my sister's serious sickness, my lord. I took steps again on 4, 10, 24, but they did not receive any.
Later on, learned counsel for the appellant entered appearance and submit that she will take best step upon respondent number.
Respondent number 7 and 10C.
7 and 10C.
C, bracket C.
10C, there is accordingly allowed. Step upon respondent number 7 and 10C be taken by registered post with AD and also by usual process. I will come to that. It's the matter after for each.
Much obliged.
26.
Make clear. So, we have literally briefed the respondent. I am appearing on behalf of the respondent. The last occasion we informed the court about it.
None appears for the applicant, the appellant or all.
Sorry, my lord. I am for the appellant. In this case, my lord, steps was taken, my lord, and steps was taken on 18/2. No report has, my lord, received, but my lord, I have checked the postal ID, and that was returned back because no such person in the address, my lord. So, my lord, if your lordship permit, I may be
serve them through the executing court because they are proceeding with the execution case, my lord.
Heard Mr. Sahu, learned counsel for the applicant. And Mr.
Edeka, on behalf of HK Deka.
A. Decker, learned counsel, appearing on behalf of Mr. H.K. Decker, learned counsel for the respondent, opposite party. Mr. Decker submits that the party has returned the brief from them. When they have returned the brief,
Because the matter was dismissed for non-prosecution and in order to pursue with the execution, the party, the respondent put the file from her. This RSA was dismissed for non-prosecution.
RFI.
Sorry.
And later on, my lord, for restoration petition along with an application for delay has been filed. And in the delay petition, notice was issued, my lord.
Mr. Sahu submits that he will take fresh step upon respondent number. Sole respondent. Upon the sole respondent. There is allowed step be taken by registered post with AD and also by usual process within a week from today. This after 4 weeks.
Date of birth, I may be allowed to serve through, my lord, executing court because in executing court, they are proceeding with the execution proceeding, my lord.
No, does the service is also perfect. We cannot direct you to serve it through executing court.
My lord, upon the advocate concerned appearing in the, my lord, on behalf of the decree holder.
Whether such procedure is prescribed in the rule.
Because he is representing
Is it prescribed in the rule?
Otherwise, in some cases,
No,
I have been
we will
directed.
go by the rule.
Okay. Obliged.
I'm sorry, no, sir. They may allow.
Part Mr.
G. Kakoti.
Kakote, learned for the applicant. Then Mr. White for respondent number 225. Respondent number 225 and Madam Copan for respondent number 1A. This regulatory application under Order 22 Rule 3, reviewed Section 151 of the Code of Civil Procedure is preferred for substitution of disease appellate number 1. The learned counsel for the applicant submits that the respondent number 1, namely Bhupen Das, suffered demise on 28/2/2023. And as such, the legal heirs of the deceased respondent number 1 are required to be implicated in this in RFA number 133 of 2019. The learned counsel for the respondent submits that they have no objection in the event of allowing this application. We are taking note of the submission of learned counsel for both the parties, then also considering the facts and circumstances of the records, this court is applied to allow this application. The legal heirs of respondent appellant number 1 is substituted in the RFA number 133 of 2019. In view of the order passed in IN number so and so, the counsel for the appellant shall file amended procedural in the RFA number so and so within a period of 1 week from today.
May it please, your lordship. My lord, this is an application for substitution of legal heir of sole petitioner, my lord, who expired on 2/4/24 and it is in time. It is filed within time, man. Details of legal heirs at page 4, my lord.
Third, Mr.
S.K. Chakraborty.
S.K. Chakraborty, learned counsel for the applicant.
That's okay.
This application under order 22 rule 3 of the Code of Civil Procedure is deferred by the applicant for substitution of the name of sole petitioner who suffered demise on 2/4/2024. So Chakraborty, learned counsel for the applicant, submits that the sole petitioner, namely Sampalal Roy.
Champalal Roy.
Sampalal Roy suffered demise on 2/4/2024, and he left behind 3 legal heirs.
Yes, my lord. Shibani Roy, Shushendu Roy,
Namely Shivani Roy and Shishendu Roy
and Simki
and
Roy.
Timki Roy, and they are required to be included in this petition. In this petition, as the petitioner. Taking note of the submission of Mr. Chakraborty, learned counsel for the petitioner, and also considering the facts and circumstances of the record, the petition is, this interlocutory application is allowed. The legal heirs of late Sampalal Roy implicated as petitioner in the CRP number 32 of 2018. The learned counsel for the applicant shall file amended postally in the CRP number 32 of 2018 within a period of 1 week from today.
29.
Oblige.
May I please, Your Lordship? Lordship, in this case, there is a series of these cases with regard to substitution of some of the parties in the second appeal. Now, IA 1853, I think, which is item number. There are. This is with regard to IF 1853. This is with regard to an application seeking substitution of the legal heirs of respondent number 1. And my learned colleague, she has filed a common objection in respect of all the cases in a single objection. Now, Your Lordship will find that the reasons of this we came to know because we are the second sets of counsel, Your Lordship. So after the case was handed over to us, we went through the records and we came to know about this while making inquiry. And this series of cases has been filed thereafter, Your Lordship. And so consequently, there has been some delay in filing this case within the prescribed period of limitation of Section 1, Article 120 and 121 of the Limitation Act, Your Lordship. Now, Your Lordship will find in this first case of 1853, we have stated with regard to para 2, if Your Lordship takes up para 2, that the petitioner begs to state that it appears from the record of RSA 162 of 10, especially upon perusal of the order dated 28/2/24 passed in the said RSA, that as per the submissions made on behalf of the counsel of the respondent before this honorable court and recorded in the order, the said order, Muhammad Kumar Ali, son of such and such, who was arraigned as respondent number 1 in the aforesaid second appeal, had expired. It is apposite to mention herein that the aforesaid fact was totally not known to any of the petitioner appellant prior to 3/5/24, the date when their newly engaged counsel had for the first time gone through the records of the said second appeal. Number 3, and we have annexed the copy of the order where it is reflected, Your Honor, Annexure I, Your Lordship will find at page 16, where the order is reflected. The order we are referring to, Your Lordship. Para 3, we have given the names of the legal heirs of the persons whom we have come to know are the legal heirs of the deceased. And Then in para 4, we have stated, para 4 is that the right to still subsists. And in para 5, we have given the explanation that the petitioner begs to state that the petitioner became aware when the newly engaged counsel had gone through it and consequently is being filed within the prescribed period of limitation, because our contention is from the date of knowledge, we have filed it within the prescribed period of 90 days, Your Lordship. This is our contention in this particular case, Your Lordship. And similarly, in the other cases also, there are delay, but the ground is same. After we came on record, we have been, while going through it, we came to know about this developments. The earlier council did not take any steps, or because as your lordship is aware, in the High Court, the cases are listed not regularly, but after a gap of numerous days, your lordship. And because of which there is some delay in, because we do not keep touch with the clients regularly. When the case comes up, that thing crops up. And for that purpose, 2 judgments I like to place on record with regard to this. And another point, my learned,
What is the objection, madam?
that is the objection is with abatement as well as.
I am asking.
This case is also there are so many anomalies. The Lordship will find. I have raised objections in all the paragraphs stating all the anomalies in filing the substitution application. As my learned friend has already pointed out, they have gone through the order dated 28/2. That order I have also enclosed. 28/2 for a moment. First paragraph it says, MSR children and counsel for the respondent has submitted that the appellants Kapila Bewar, Hazrat Ali, Muhammad Malikjan Bewar, and Mohammad Fatih Mahmud Sheikh have expired long back. So this is the submission of from my side, Lordship, about the death of the appellant. And thereafter we come to respondent number 1 first. According to
On that day, this was not the engaged counsel of the.
Separately, I filed.
Whether any bar council lordship complaint was filed by the appellants before the bar council about lordship against the earlier set of appellants. That is one point. There was no such objection raised by the appellants.
No, is there any requirement that they have to file
Yes, lordship, they have
complaint
to file-
before the bar council?
They have to file lordship complaint before bar council against their suddenly they have changed their lordship engaged counsel and now coming with this application. Taking the benefit of changing counsel lordship whether this is a sufficient cause. And moreover, lordship, there are names of appellants I have mentioned in the order itself. In spite of that, they have filed only 2-3 substitution applications. Malikjan Bewar, they have not filed any substitution. Only Hazrat Ali was filed and Fatih Mahmud was filed. Malikjan Bewar, Kapila Bewar, there was no substitution application. And moreover, lordship, I in the order itself reflected that the respondent number 1 died on 17/9/2009. So from the date of death only, lordship, they are required to explain about the event. But from the date of knowledge, they have explained. And from the date of knowledge, lordship, they have explained only about the death of respondent number 4. Other 2 respondents, they have not filed any substitution. And from 17/9.
So how many respondents are there?
Lordship,
Respondent 1 died and appellant 1, 2, 3, 4 persons died. The appeal already abated by the death of the other appellant. It's a joint decree. And moreover, lordship, for 1 respondent or 1 applicant, 3 applications has to be filed. But here in this case, for respondent number 1, only 1 substitution application. Without any setting aside abatement, without any confirmation application. In substitution of respondent number 1, 1853. And for 1B, appellant number 1B, 2 applications, confirmation and substitution. And for Applicant number 3, substitution and contradiction. There was no setting aside abatement for any of the applicant nor respondent. For the respondent number 1, only one substitution. There are so many elements in Lordship. They have entered appearance only signing wakalatnama for 3 applicants. How can they file substitution application for applicant number 1B or 3 without any wakalatnama? I have gone through the entire record, Lordship. There is no wakalatnama for the substituted.
I
to
think
the
there is,
legal heir.
it has been filed.
In the IA also I have checked, there is no wakalatnama. Without any wakalatnama, how applications were filed?
We have filed. Yes, sir. This one, yeah.
Mr. Biswas, you check the records.
We'll check the record.
On earlier occasion, I have checked, there was no such.
Let me check.
Maybe later on, if they have filed, I have no idea. But it is required to file the wakalatnama along with the application.
At 2, your lordship, you will just
So,
go through.
will take it up today or on another day?
Another thing, let her go through it. Let her go through the record. Let's see if she
Okay.
says that. I don't think so. There is any anomaly
As
in that
cited by
sense.
learned advocates of both the parties, there is this matter on suggested
Any date, your lordship.
27th of March.
Obliged.
Then not. Like,
27th.
My lord, that in item number 8 and 9 is just password for time being, my lord. The matter relates to hearing, my lord, final hearing, my lord. So let the matter be any Tuesday or Thursday, my lord. Item number 8 and 9, or next Tuesday or Thursday. So tomorrow, the Thursday, is 8 and 9. That this respondent advocate is that he would record.
So the matter has already been fixed on 28th of May.
Yeah, 20th tomorrow actually, but it is listed today. My lord. There is a difficulty. Maybe listed next Tuesday then, my lord. Or tomorrow, if the matter comes, then.
Next week. Okay. As cited by learned advocates of both the parties, basically it is
Either next
matters
week,
7 and 8.
25.
On 25.
25, my lord. Obliged.
Okay, then my lord may fix it some other day.
We have filed objection against the condemnation petition. If the condemnation allowed, then the question of hearing other petition will come back. They are just more than 3 years delay in filing the petition. And the first shown is not satisfactory. I am giving you as my lord.
No, my lord, we have shown 1,446 delay, but registry has calculated by excluding the period of COVID period, my lord, 612 days. They have excluded the period of COVID period, my lord. 612 days delay in preferring the
But I not people hear the condemnation or we heard only together.
No, this application for condonation of delay is 3 people for. 3 people for.
Yes, yes.
This petition is listed for the first time today, and
Yes.
no notice has been issued.
My learned friend appears for the respondent.
But that's all right. But
Okay.
he has filed objection. In which petition you have filed objection?
3,444, my lord. In the delay petition.
Acha. So, okay, you argue the matter.
Yes, my lord. I have explained it paragraph 3, my lord. Kindly see page 4, paragraph 3. Basically, my lord, the appellant number 1 is looking after the matter. And after his death, they were unaware of the that any case is pending. Therefore, when they have received a notice from the executing court, they went to their local council at Bishana Charali. Then they have informed, he has informed that one the second appeal is pending. They came to Guwahati and met the council at Guwahati, my lord. And the council at Guwahati suggested them for filing the petition. Though they have come late, therefore they have to file another 2 petitions. Otherwise, within 90 days, they have to file. That I have explained in paragraph 3, page 4, my lord.
The second appeal was disposed of by this court.
No, my lord, not disposed of. For that, my lord, computer was showing wrongly as disposed of item. That is why it took some time. It was not disposed of. Wrongly reflecting.
Then what is your objection?
Actually, finally, it was shown in the condemnation petition not satisfactory. Because Hariprasad Sharma and Baldev Sharma both are brother, my lord. Both are appealed in the High Court. Hariprasad died, and Baldev Sharma knows it very well. And then doing for the last 3 years, they have not filed any objection to the petition for substitution, which has to be filed within 90 days from the date of the year. Moreover, in their objection petitions, my lord, they have stated that in para 5 of my objection, that they beg to submit them. In para 2 of that petition, the petitioner has stated the appellant Hariprasad Sharma died on 29th 2020. But in para 3, my lord, priority date 29, 2022.
That was a typing mistake, ma'am.
Died, my lord. Without the death certificate, it cannot
I have
be
annexed the
asserted
death
on which that he died, my lord. One is 20, and is 22, my lord. That is as the Baldev Sharma is alive, he is also appellant. He knows that his brother died and case is pending in the High Court. He could have taken state must within the period of limitation, my lord. So that the now present petitioner, the legal heir of the Hari Prasad Sharma, that the case is pending in the High Court, they do not know that it's not believable, my lord. Because the wife had sought must know if only case is pending before the High Court, my lord. More their uncle, that is brother of Hari Prasad, he is living, he is also party, my lord. So the cause shown in the petitions are not satisfactory cause, and then it is falsely manufactured just to save the period of limitation, my lord. The Hari Prasad, a Baldev Singh, he being his own brother, he being the appellant, he knows that case is pending in the High Court, and he should have taken stay in time, my lord. So the cause shown is not satisfactory and reasonable cause within the meaning of Section 5 of the Limitation Act. So delay cannot be condoned, my lord.
No, the appellant number 1 is all throughout looking after the matter. And they being the village people, my lord, they are not aware of the niceties of this legal procedure, my lord. And they only came to know only when the executing court issued notice. That some case is pending. And in the High Court.
In matter para 7 of my petition objection, so the deponent opposed party beg to submit that the aforesaid statement of the petitioner cannot be believed because the appellant number 2, Baldev Sharma, is the own brother of the deceased appellant. Hari Prasad Sharma knows about the pendency of the case in the High Court matter. High Court and also the death of his brother, Hari Prasad Sharma, and as such, ignorance about the pendency of the case before the Honorable High Court by the petitioner cannot be believed, and as a long period of delay cannot be condoned by believing the unbelievable by believing the unbelievable cause shown by the appellant in this petition. The para 8, the party begged to submit that the appellant Hari Prasad Sharma died on 29th, 2020, and the co-appellant Baldev Sharma, brother of the deceased Hari Prasad Sharma, know about the pendency of the case. At the Honorable High Court, he should have taken step for implementing legally within the period of 90 days, my lord.
Okay, we will examine the matter and pass order.
Okay.
First, we will dispose of this I.
Man.
I have
Obliged.
covered everything in my objection, my lord. Your lord kindly peruse.
We will
Deeply
take note
obliged.
of the same.
Deeply obliged.
34.
May it please your lordship. In this case, lordship, I have filed one IA for implement of the legal heirs of the sole respondent, lordship. The sole respondent who was made party in the second appeal is a dead person, lordship. And in this case, lordship, the decree was for right title interest and recovery. In execution proceeding, lordship, the suit land was already handed over to the petitioner's lordship, to the legal heirs of the decree holder, lordship. So I have filed one application that the legal heirs may be implemented in the second appeal, lordship, to which my learned friend has filed an objection petition, lordship. In fact, lordship, in appeal, it is the duty of the appellants to implement the legal heirs, lordship. But as my learned friend is not aware about the legal heirs name and address, so I filed this application for implement, lordship. I have annexed along with my application. Annexure 1 is the death certificate. Your lordship will kindly see page 10. Our father died on 3/1/21, lordship. And thereafter, annexure 2, lordship, order sheet in the execution proceeding, page 11 it starts, lordship. page 12, Your Lordship, last paragraph, by petition number 605, decree holder has submitted that he took possession of the suit land with the help of Nazir. And thereafter, Lordship, the judgment debtors again disturbed in the peaceful possession of the decree holders and dispossessed them. So another application was filed, that is Annexure 3, page 17, by all the legal heirs of late Jamaluddin, Lordship. Your Lordship will find in the matter of Musammad Rejia Khatun, aged about 64 years, wife of late Jamaluddin. So before the executing court also, we have filed this application by all the legal heirs of sole decree holder, Lordship. In this decree, in this petition,
What is your objection?
My lord, in this case, I am sorry to submit a file objection only to the point that it is a particular statement and submission made by the petitioner, applicant, you know. This case, as per the statement, my objection petition may be perished, my lord. Objection petition during the trial of the above title suit number 2515 in the court of Planet Munship number 2 Morigao, the sole plaintiff responded died on 13/1/2021. 3/1/2021, my lord. As per death certificate of deceased Jamaluddin, who is annexed by applicant as annexation number 1, as shown is page number 2. Very important. So there's for the first time, this death certificate produced before this lordship court. No any such petition was filed at the trial court or appellate court or execution court. So why this death certificate suppressed? I am coming to the next point, my lord. As per their allegations, on petition paragraph 2 of their application, Jamaluddin died on 3/1/2021, paragraph 1 of this applicant application. Now, here, lordship will find I have annexed one, the judgment and order annexer in my objection petition, page 41. This will be judgment delivered on 13/1/2021. So, it is a later judgment, he died long back. So during pendency, this title suit, the plaintiff itself died, showing in the orders it reflects that date of judgment, my lord, annexer A, I have annexed in my objection petition. It is the TS number 25 of 2015, order dated 12/1/2021. Plaintiff is duly represented. That means plaintiff is personally present. That means decree was duly represented 2 days. It was fixed for judgment. Judgment is ready, signed, and read over and tagged with the case record. By my separate order announced declared in the open court, the suit of the plaintiff is decreed on contest against dead person, my lord. This judgment was obtained in favor of a dead person. Advocate was present, party was present, showing that by filing Hazira, my lord, on that date, he is alive. So this judgment decree was obtained fraudulently, misleading the honorable court, suppressing the date of the death, because he already died on 3/1/21, my lord. So the judgment delivered on 12/1. That is why I am to file this objection. Judgment obtained against death man is a nullity, my lord. Your lord is very low. So why suppressed? Death certificate not produced. No information was given before the even, my lord, against the objection aspect is fraudulent judgment degree. The learned court passed the decree that the party decree that is alive. Now in appellate court also found there is no any death certificate, no such formal petition filed by the respondent, my lord, that informing that court that he must be implicated as a party. Now, Your Honor, lordship's file in the title during the pendency of title appeal, my lord. When they, as per their allegation, he was a dead person. but no death certificate. No application was filed, not informed before the court. Why they appeared before the contest the case in the appeal, my lord. Now, your lordship is filed. Surprisingly, in the petition and in the applicant paragraph 3, last portion, my lord. LCR page 61, shown one petition filed before the appellate court. My lord, this is a fabricated petition. No any whisper against in the order sheet of receiving by the court. Learned appellate court, trial appellate court did not receive this petition, although they are challenging that they filed this petition. It is a vague petition. That may be very particular. When the petition also shown that respondent Jamaluddin died on ... Learned court himself noted. There's no date of death, no death certificate, no affidavit was filed. Is that showing that he was dead? They even when they already died, death certificate in their hand. The learned advocate and other side also not produced a death certificate. So learned court did not take any note that he died. So he was alive. No such proof. Now, as per their own allegation, LCR, my lord, maybe very important. LCR page number 61, learned in this.
We will see, but
LCR, my lord, LCR 62, page number 62 may be ferrous. Another important petition filed also, although filed by the applicant side by advocate, showing different date he died long 2020 years. 2020, not 21 on that particular date. So two different false dates showing by them. Death certificate not produced before the trial court. Judgment obtained against the dead man. Dead plaintiff, my lord. Even appeal was filed, but no death certificate was produced. Not informed that also on so particular date he died. It was not to the court or appellate court.
can all these matters we can decide in this interlocutory application?
My lord, only I'm reflecting something the points that his contradiction judgment or degree was obtained against dead man, he was already dead. So appellate court held that there was no any record that he is died. No information to the appellate court. So judgment was passed against that defendant, showing him alive. So appeal also filed, second appeal also filed before the lordship against the respondent, showing him alive. So because the appellant had no knowledge, neither appellate court had knowledge of Lord Appellate Court regarding that. Now, for the first time, some persons has appeared, so I wear the legal hair. So our father died before the lordships. So information, petition is filed. So they could have filed any petition. If also it is alleged that we have not made them party, how we will make party? Appellate judgment shows that he is alive. We also know the alive learned appellate court knows such alive. Order Perus maybe order page number 62 LCR, my lord. Clearly stated no wrong different date of death, no death certificate,
No,
birth certificate.
Mr. Hussain, you see, now they have produced the death certificate before this court.
My submission in this regard, my lord, they want to implicate regarding that I'll submit only the contradiction. The allegations, the date of death.
Maybe those may be there, but now they have produced the death certificate before this court.
Yes, my lord. And they are showing that they are there. In this regard, I have nothing to submit because already if a deceased person.
No doubt the points you have.
That may be reflected, my lord. He's a dead man.
No. In this IA, why should we reflect the same? In the RSA, we may reflect the same. And unless we dispose of this.
This petition is filed order 112 learned court has jurisdiction to at any party at any time. So that is other when in violation of order 22. I am also not there. So when petition is filed under order 1 rule 10(2). So at any time or whenever court has jurisdiction to implement or bring all the.
Let us implement them.
Provision is there.
Okay. Order 22, Lordship, that is applicable to the appellants only, Lordship. I am respondent. Normally in second appeal, appellant's duty to implead any person, Lordship, for substitution. So here, Lordship, my father was respondent, so I am not blaming my learned friend, as because the appellate court judgment shows the name
No,
of
alright,
disease.
madam, we are allowing this petition.
Lordship.
We will hear the RSA on Friday.
Lordship.
Well, a substantial question of law in that also not framed. Only notice was issued, they also not appeared and not neglected for 3 years. Now they have come, my lord. So substantial question also not framed. Also
For
submitted,
that, Lordship, the RSA will be listed in order 41 column, Lordship.
simply notice was issued, my lord. So it should come for admission.
Yes,
Addition
we
case.
admitted only on substantial question. So, okay. Third is Sodori, learned counsel for the applicant, then Mr. Hussain for the respondent, opposite party. This application under order 1, rule 10, within bracket 2, related section 151 of the Code of Civil Procedure is deferred by the applicant seeking impleadment of the seeking their impleadment as respondent number 1.1 to 1.7. Replacing the existing deceased sole respondent in connected RSA number 6 of 2024. Peruse the petition and the documents record, and also peruse the death certificate of Jamaluddin, the sole respondent, which is annexed with the petition as annexure number 1. Annexed with the application as annexure number 1. It appears that Jamaluddin died on 3/1/2021. In view of above, there is a requirement for impleading now for impleadment of the respondent number 1.1 to 1.7 in place of Jamaluddin, who are the legal heirs of late Jamaluddin. Further, having heard the submission of learned counsel for both the parties and also taking the facts and circumstances of the record, this court is inclined to allow this application. Respondent applicant number 1.1 to 1.7 shall be treated as respondent number 1.1 to 1.7, the RS number 6 of 2024. Corrected. Subtitle shall be furnished within a period of 1 week from today.
Lordship, now appellant may be directed to amend the cause title of the appeal memo, as
Appellant.
I am not the appellant in that regular second appeal, Lordship.
The appellant
Only if
shall
your
file
Lordship
corrected
dismisses
subtitle
petition.
within a period of 1 week from today.
It is a jurisdiction and power of the honorable court to itself to amend the implead them only, just to implead, not to amend.
So,
Handwriting impediment is nowadays not maintainable, Lordship.
Hard is hard Mr. Hussain, learned counsel for the appellant and Mr. Chaudhary for the respondent. It appears that no notice has been issued to the respondent. Substantial question of law has not yet been framed and the appeal has not yet been admitted. Accordingly, it is provided that justice shall leave the matter under order
41 Rule 11.
order 41 rule 11.
Next week, any date, Lordship?
They still fix it. After DO,
Next week, Lordship, it's a long pending case, Lordship.
no, it is 24 matter.
Lordship. Now, order 41, Lordship, the motion stage, it has not covered yet. Only notice was issued in a concurrent. manner.
Therefore, we have directed the listed to listed for pending of substantial question.
On 25, Lordship, order 41, Rule 11, 25 March, Lordship. It will come in the order 41.
We have number of cases
Lordship.
before vacation. So second week of
After vacation, my lord, or otherwise, after vacation.
after vacation,
Correction.
suggested it and take it.
Correction also there, record correction also.
Lordship, and an appeal memo may be furnished.
Oh, yes.
Appeal memo at the DDP.
बस
Please, Your Lordship. I am for the applicant respondents, this matter. We have filed an IA to vacate the stay order, my lord. There was an injunction order. What had happened, my lord, is in this case is that the respondents as plaintiffs filed a title suit against the revision petitioners, my lord. Along with that, my lord, they also filed an injunction petition under Order 13 and Rule 1. And that injunction petition was allowed, my lord. The learned civil judge junior division was of the opinion that the three golden principles that needs to be satisfied before an injunction order is granted, that is a prima facie case, irreparable loss, and balance of convenience, they were all satisfied by the plaintiff respondent. And accordingly, the injunction order was passed. Being aggrieved, my lord, the revision petitioners preferred an appeal. The appeal was dismissed, my lord, and the order of the learned civil judge junior division was upheld. Against the concurrent findings of the court below, my lord, they have now preferred this revision petition under section 115 CPC, read with article 227, my lord. Now, my lord, the defendants are in possession of the suit line, my lord. The title suit is pending and an injunction order was granted. So, my lord, now, my lord, and both the courts below have come to concurrent findings, my lord, that the injunction order is right, my lord. So, my lord, now this revision petition does not lie, my lord. Even the Honorable Apex Court, I have the judgments with me, my lord, and the Guwahati High Court has said it absolutely clear, my lord, that when it comes to exercising revisional powers under 115 CPC, my lord, that will be interfered under concurrent findings only if there is a jurisdictional error, my lord. And this is not a case where there is any jurisdictional error, my lord. Both the courts below had the jurisdiction to pass the order. An injunction petition was filed, injunction was allowed, and then it was again upheld, my lord. So now this revision petition is not maintainable, my lord. I have the judgments with me, my lord. And the IA, my lord, is to vacate the stay order, my lord. The injunction order was stayed, my lord, on the very first day itself, my lord. The order dated 11/12/24, my lord. The injunction orders were stayed, my lord. The position is absolutely clear, my lord. The concurrent findings of the courts below will not to be disturbed while exercising revisional powers. Yes, my lord. The first judgment, my lord, is from the Honorable High Court, my lord, 2004 1 GLT 210, my lord. Paragraph 10, if I may read, my lord. May I read, my lord? After a threadbare discussion of the effect of the amendment of section 115, the Apex Court has held that the High Courts, while right in High Courts were right in concluding that the revision applications, which were subject of discussion in Shiv Shakti Cooperation Housing Society, Supra, were not maintainable. The fallout of what has been discussed and pointed out above is that no revision will now lie against an order granting injunction or refusing to grant injunction under Order 31, Rules 1 and 2, and or under Section 151 of the Code, as well as the orders allowing or disallowing the prayer for injunction in exercise of powers contained in Order 43, Rule 1, read with Section 104 of the Code. Para 12, my lord. One may also refer to the case of Surya Devi Rai versus Ramchandra Rai, reported in 2003, 6 SCC 675, wherein the Apex Court has observed Section 115 of the Code of Civil Procedure, as amended, does not now permit a revision petition being filed against an order disposing of an appeal against the order of the trial court, whether confirming, reversing, or modifying the order of injunction granted by the trial court. The reason is that the order of the High Court passed either way would not have the effect of finally disposing of the suit or other proceedings. The exercise of revisional jurisdiction in such a case is taken away by the proviso inserted under subsection 1 of section 115 CPC. And my lord, para 13 says, in view of the above observations made in Surya Dev Rai Supra, there can be no escape from the conclusion that no revisional jurisdiction can be exercised by the High Court under section 115 of the Code in respect of orders.
Next judgment.
Next is, my lord, of the Honorable High Court, my lord. My kindly the para 17, my lord. I'm reading just the last paragraph. Similarly, in the case of Bhojraj Kunwari Oil Mill and Ginning Factory versus Yograj Sinha, Shakrendra Sinha Parihar, 1985 1 SCC 149, it was observed in para 4 as under. Against this order, a revision petition was preferred, which was heard by the learned assistant judge. We find it difficult to appreciate the approach of the learned assistant judge while exercising revisional jurisdiction in interfering with an eminently just order. And the High Court disposed of the matter, observing that the grounds urged by the appellants for seeking condonation of delay were obviously no grounds at all. Against this approach left us unconvinced. If the trial court had the jurisdiction to condone the delay, we find no material for holding that there was any impropriety in exercising its jurisdiction. Therefore, we are of the opinion that both the learned assistant session judge and the High Court were not justified in interfering with the order of the trial court and exercise of the revisional jurisdiction only on the ground that a different view of the facts elicited was possible. This approach hardly permits interference in exercise of revisional jurisdiction. In view of the above, my lord, the revision petition was dismissed, my lord. Then, my lord, the third judgment of the Honorable Supreme Court, my lord. Para 8, let me read, my lord. In Hindustan Aeronautics Limited versus Ajit Prasad Karve, 1973 SCC 195, this court observed as follows. In our opinion, the High Court had no jurisdiction to interfere with the order of the first appellate court. It is not the conclusion of the High Court that the first appellate court had no jurisdiction to make the order that it made. The order of the first appellate court may be right or wrong, may be in accordance with law or may not be in accordance with law. But one thing is clear is that it had the jurisdiction to make that order. It is not the case that the first appellate court exercised its jurisdiction either illegally or with material irregularity. That being so, the High Court could not have invoked its jurisdiction under 115 CPC of the Civil Procedure Code. See the decisions in the following cases, my lord. Then para 9, therefore, we are of the view that the impugned order of the High Court is liable to be set aside and the orders passed by the courts below are to be restored. So, my lord, the scope of interference while exercising revisional jurisdiction is very limited, my lord. Especially when both the courts below have passed the order of injunction in favor of the plaintiff respondents, my lord. So, my lord, the injunction order, my lord, deserves to be restored, my lord, and the stay order should be vacated, my lord. This is my submission.
Yes. Well, they are raising issue like maintainability. So it may be hard finally. We'll argue.
No, this interlocutory application.
Interlocutory.
I mean, stay order may can be vacated, my lord. This prima facie, my lord, revisional jurisdiction, my lord.
Facts are different. They are relying upon the judgment, they are different. Like our case is different. The public institution, they wanted to give a public institution land, my lord. And you have to do a CRP.
No, no.
Gotcha.
So for public institution, the law is not different.
My lord. That's correct. But as per the facts, look, they are not correct. My lord. And whatever we have projected.
No, forget about your facts. What is your submission in respect of the proposition of law laid down in these cases referred by him?
My lord, today we are not well prepared and they are
Okay. Mr. Mahmood, you furnish copies of this judgment to him.
Yes, madam.
Yes. You please go through it. Yes. And we will hear you on Friday.
Can the IMA can be disposed of today, my lord? The main CRP may be heard on the other day. The injunction order may can be restored, my lord.
No, let him go through the judgment.
Yes.
Heard Mr. S.A. Mahmood, learned counsel for the applicant. And also heard Mr. Learned counsel for the respondent opposite party. Mr. Mahmood, learned counsel for the applicant submits referring to two decisions of this court. In Renuka Devi Kusaria, within bracket Oswald and another versus Triveni Devi Tiwari and another and other. Reported 6/2016 SCC online PAU 677 and Suresh Kumar Dhanuka and Kedarnath Dhanuka reported in 2004 DLP 1 page number 210 and one decision of Supreme Court in
2009-17 SCC.
Home Care Retail Marts Private Limited versus New Era Fabrics Limited reported in 2009 SCC 17 page number 429 submits that The revision petition is preferred against the order of appellate court
Yes, ma'am.
confirming the injunction granted by the trial court, and the said CRP is not maintainable, and the interim order passed in the aforesaid CRP saying the order of injunction is required to be vacated, and therefore it is contented to allow this application. The learned counsel for the respondent opposite party submits that he may be furnished copies of the judgment relied upon by learned counsel for the applicant, and also may be given some time to go through the same and to respond this court. Here is accordingly allowed, leave the matter on Friday. Mr. Mahmood shall furnish copies of the judgment to the learned counsel for the respondent during the course of the day.
My lord, can it be on 25, Tuesday? No, my lord, there's an urgency, my lord. The injunction order has been stayed since December, my lord.
Let it be on Friday.
May I please?
May it please the Lord. Firstly, I am appearing for respondent 1 and 2, ma'am. For an experiment in order to file the written of.
These are a substitution petition as well as an abatement with regard to respondent number 3, your lord. So
That's all right.
I have already served that copy to them.
Article services, learned counsel for the applicant.
Appealing for respondents 4 and 5.
And Mr. A Dekka, learned counsel for respondent number
1 and 2.
1 and 2, and Mr. Bhattacharya for respondent number
4 and 5. State
4
of
and,
Assam.
4 and 5. This interlocutory application is preferred under section 5 of the Limitation Act, seeking condonation of delay of 972 days in filing application under order 22-41 between section 151 of the Code of Civil Procedure in RSA number 3 of 2021 for substitution of the deceased respondent. What is the name of the respondent?
Lordship,
Radha Bosma, who expired.
the Radha Basmati.
Radha?
Bosmutari.
Radha Bosumotari. This is respondent, namely Radha Bosumotari. Mr. Dekka submits that he may be granted some time to file objection. Here is allowed. List the matter after a week.
2 weeks, my lord.
Okay, 2 weeks after 2 weeks.
A date may be, your lordship. Obliged.
May it please your lordship. Lordship, I was the plaintiff in the original suit and it was decided in my favor. Presently, the second appeal is filed by them. It is in the second appellate stage, your lordship. I have filed this IA because during the suit, your lordship, I have exhibited many documents, your lordship. Out of that, there was a death certificate of the husband of the plaintiff and the father of the plaintiff, which the plaintiff wants back original, your lordship. So a certified copy or a compared copy may be kept in the record and the original may be handed over. That is the prayer, your lordship, from the LCR. Exhibit 10 is the death certificate of one Biswajit Singha, who is the father and husband of the plaintiff.
Any objection? No. Heard Mr. Mukherjee, learned counsel for the applicant, and Mr.
And Sharma.
N. Sharma, learned counsel for the respondent opposite party. This application under order 30, Rule 9 reading section 151 of the Code of Civil Procedure is prepared by the applicant for the purpose for returning original death certificate, which is exhibited in the suit. Exhibited in the suit. And that the said suit is declared by the learned trial court, and against the said decree, judgment and decree, appeal was preferred before the first appellate court, and the same was
dismissed
by the learned first appellate court, and against the judgment and decree of the learned first appellate court, One second appeal is prepared, being second appeal RSA number 199 of 2011, and the record of the learned trial court is also in the said RSA. Then that the original death certificate of
Biswajit Sinha,
Vishwajit Sinha
Exhibit 10.
was exhibited in the state title suit as exhibit
10.
10. And that the said original document is required. For what purpose it is required?
Lordship, that is not stated in the petition. They don't have a copy of the document, any copy of it. For some land related purpose.
In connection with some land related matters, and therefore it is contended to release the aforementioned exhibit by keeping the certified copy of the same with the record. The learned counsel for the respondent submits that there is no objection in releasing the aforementioned document in favor of the applicant. They are taking note of the submission of learned advocate to both the parties, and also considering the practical circumstances. On the record, it is provided that registrar shall release the document, release the death certificate, exhibit
10.
Exhibit 10 to the applicant, keeping a certified copy of the same on the record. But the applicant shall produce the same before this court as and when directed.
Worship, sorry to, on 9th, I will be out of town. Another date after Bihu may be fixed.
10:30.
Oblige.
May please, Your Lordship. I am for condonation of delay with. Okay, please. We have filed an RSA against the judgment and decree dated, but there is in 141 days delay, my lordship. This is the notice may go on, there is a sole respondent.
So this application is for condonation of delay in filing the regular second appeal.
Yes, my lordship.
But the appeal has already been registered. How is it
Not
registered?
registered, no, at this system notice may go, my lordship. At this system notice may go. Appeal is not yet
It is
registered.
filing number, correct? Not
Yes, my
registration
lordship.
number.
Filing number, filing number.
Artist Begum.
Arvegam.
Or Begum learned counsel for the applicant. This interlocutory application under section 5 of the limitation act is deferred for consideration of delay of 141 days in filing appeal. In filing regular second appeal against the judgment and decree dated 24th April 2024 passed by the learned civil judge senior division Surat, money appeal number 2 of 2022. Ms. Begum, learned counsel for the applicant submits that there is delay of 141 days in filing the connected regular second appeal, and as such, the delay is required to be completed. That notice be issued to the respondent, opposite party,
Sole respondent.
respondent opposite party by registered post with AD and also by usual process in a week today. It's after 4 weeks.
Of license. Please, Your Lordship.
Lordship, this is an application for condonation of delay of 66 days, Lordship, in preferring the amnesty appeal, Lordship. It has come for the first time,
Let topic after 4 weeks.
Lordship.
Right.
Must oblige, Lordship. Lordship, the case is listed for the first time
In this case, there was 7 days delay for filing appeal. So notice may be issued.
Okay, after for
Nice.
May I please, Your Lordship? I'm for the petitioner, my lord. Here I have filed a civil division petition against the order passed by the learned civil judge senior division Gulaghar, by the order dated 5/3/2025, whereby on the basis of oral submission made by the government pleader on particular date when case was title suit as well as injunction petition was pending for a quite long time, and that day was fixed for injunction hearing. But on the basis of oral submission made by government pleader, that due to this under provision of section 63 right to fair compensation act, this civil suit is barred. And first, my submission is in this regard, my lord. I would have given at least one opportunity to produce or submission given reason. This is on the basis of oral submission. As this matter, along with injunction petition, this is to be heard for injunction petition. Then no opportunity is given. That is also one kind of natural justice, violation. Now, another point, my lord, whether 63 of right to fair compensation, lordship have to produce the act. Right to fair compensation and transparency in land acquisition, rehabilitation act. Lordship got it. Right to fair compensation. Fair compensation, transparency in land acquisition and rehabilitation and resettlement act 2013. Lordship may peruse the order. Impugned.
the order is at page number 117.
That is, the lordship is taking an injunction petition or title suit before lordship? CRP or 39?
This is CRP.
CRP, my lord. In
Order
that,
was passed at CRP.
CRP, my lord, your lordship will get it. And CRP will get it, no? Yes, my lord, that is page in my CRP, that is 114, my lord, page. NSR 16 is starting from 113, my lord. Lordship, got it? Here, lordship will get it. And the title should, he has
Mr. Borua,
my lord.
this is against the injunction order passed by the learned civil judge.
Civil judge. That is next page.
Whether this civil revision petition is maintainable against.
Because here, my lord, it's a maintainable. Why? Because it is petition is dismissed. Petition is dismissed again, response number 2, my lord.
I am showing you some judgment of Supreme Court.
Note down.
You please go through these three judgments and thereafter you submit whether it is maintainable or not.
Against my injunction petition dismissed, but title suit also dismissed, my lord. Title suit also, again, just number 2 is dismissed and injunction also followed. Now I'll go through, my lord, definitely. My lord, here, my humble understanding, I may be wrong because I have just not gone through. Here the case, my lord, trial court would have passed some order. But that is not so no. Because my order case has been dismissed against them. That too without hearing me. Violation of self-justice. In WS, when WS they have filed, this the district commission respondent number 2 has clearly said this act, paragraph 16, my lord, I have that day also, I mentioned today also, paragraph 16 of the WS, they have said that this act is not applicable for you. One thing. On the other hand, when this injunction petition about to be heard, before that one date was passed 17/2/2025, the court held that this is having interest because he's having personal interest in this case. Because as per this law, if I am this road is required to be constructed by acquiring the land. Here question is coming whether my tenants being a tenant, whether I having personal interest or not. That is question is to be decided. That was the issue before this. Because when notice this one there, I was holding this number, I due permission from the municipality board, they know. Then thereafter, without verifying my documents, coming to me, stated they have paid to land compensation to landowners. Thereafter, we have approached the district commissioner. He has invited 2 meetings. First meeting, he not appeared. Landowner. Second meeting, he agreed. But thereafter, not finalized. That is why I am entitled for this. If I go by this act, my lord, by act, because here lordship is putting question to jurisdiction, my lord. That is the question is coming. Now, I may be also wrong because this type of situation is reversing because suddenly he keep on very first day, you would have been jurisdictional issue would have come very fast. They have contested the case. They have contested the case up to WS and up to filing written objection. Written objection, they have not taken this issue. Now, fine morning, when the injunction petition is to be heard, that is to be heard. Rightly, wrongly, it has got in favor of me or that is immaterial. Then when the government pleader will come and say, no, as per provision of 16, because 63 it is jurisdiction is not there civil court, you have to go to under provision of 22627. Am I, because this case is very, this was not, even jurisdictional issue was not kept open also. That day, when final, I may be allowed at least, even these matters, even I'll come to High Court also. High Court our judgment. Why 63 will be applicable, that also I'll come. Maybe again, I'm telling. Interpretation part is always lordship, and we always go by interpretation. Here, my lord, morning day says, my dad, you do not have jurisdiction, the civil court doesn't have jurisdiction. No, you dismiss on the basis of section 3. Whereas you first you have said, no, section A, this act is not applicable for you. On the other hand, you are dismissing my petition on the basis of state act. At least that is why I may be hard. Here, my lord, is where not only question of this one share. It is this part here title is to be title should has filed because we have to consider, they have to consider my share, my portion, whatever I'm supposed to get it. Which will decide it? Trial court will decide it. You would have, at least I would have given an opportunity. My submission before as on date, my lord, even same submission, you didn't have been given one opportunity. Okay, they are telling us your government pleader is saying submission. Okay, maybe fine, all submission. You are giving an opportunity next day. You go for hearing. At least you are.
If the trial court has no jurisdiction to entertain the petition, how can the trial court hear
Yes,
the matter?
that is the things. That is the things, my lord. That is why I'm coming. That is my point, my lord. Jurisdiction issue. Jurisdiction issue. They have raised oral submission only. They have not filed application. They have submitted one of you do not have jurisdiction. At least am I putting question myself, my lord? Am I not entitled for defending this issue to argue on this point? Suppose jurisdiction when it is not there. When it is not there. 63 is not there, but whenever question of party title is there, title or interest is to be decided, how much share you will get it, then 62 will not applicable. Our lordship will put it this one to one judgment only, I have got it. This may be this one. This is the judgment I would have placed before this. I would have given opportunity for at least this judgment of this honorable, our honorable High Court. Jurisdiction, today, suppose my lord, my learned Advocate General will say no jurisdiction. Am I not entitled for defending this? He may be this one, he may be saying that there is no jurisdiction. Court has to hear me also, because this is not a past day case. It is my question of livelihood, my lord. My title is to be decided, because this is a question. Already, if my decision demolished, nothing survives. At least I would have given opportunity for that hearing. Simply suppose down the line a friend will say, no jurisdiction.
Okay,
Yes.
Mr. Mazumdar.
At least I should have given opportunity. What?
Many questions are coming. I'll respond to all this.
Next, before you start it, then because I'm before your lordship, my question of livelihood, I am seeking justice from this. I may be, my due to my fault, my client should not suffer. I would have gone other firm. I may be given that opportunity also if required. Till that my something, I may be protected. If because building is, my shop is demolished, nothing will survive. And its road is already been constructed. That I have photograph I have given. This is my submission. But I may be at least.
Well, first of all, the three judgments which possibly my learned friend appearing in one of the cases earlier, your lordship was hard to remember. That against injunction, temporary injunction, concurrent finding of fact, no revision lies. And since your lordship is handed over these judgments to my learned friend also, I'll just respond to that. What has happened, my lord? After this.
So here, of course, there is no concurrent finding.
No, that is
But,
number one.
even then, whether this civil revision petition is maintainable against the injunction.
Well, I'm coming to that. So far as that is concerned, my lord, in that Supreme Court judgment of 2009, if your lordship goes to the first or second, in the first page it says down below, the finding of the Honorable Supreme Court is the judgment passed by the court below is not arbitrary for the purpose of exercising power under Article 227, meaning thereby that if the order passed by the court below is arbitrary, 227 petition will lie. And what has happened actually, after the amendment of CPC in 2002, exists an order passed in any case, interlocutory order, if the order which was against him had gone in his favor, would have disposed of the suit, then only 115 petition will lie, otherwise not. Any order which is against him, the 115 proviso says if it was passed in his favor, it would have disposed of the suit itself. In that case, revision under 115 will lie, otherwise not. And so far as injunction is concerned, my lord, now the law is very clear. Injunction, whether granted or refused by the trial court, appeal lies. When initial order of issuing notice without granting injunction, interim injunction also, ex parte, against that also appeal lies, no revision. Number one. If there is an order passed by the trial court either rejecting or allowing, against that appeal lies under order 43 rule 1. But if a party, one of the parties is agreed by an order passed by the appellate court, against that a revision under 115 will not lie. But a revision under 227 will always lie.
Revision?
Under Article 227.
Will lie.
Will lie, man. Otherwise, where will he go? He cannot go directly to the Supreme Court against that order. So 227 petition will lie. Possibly there will be here from the another judgment in the same book by 2003 SCC. There are two judgments. One is Surya Devi. The other one is one after the other. Other one is Shiv Shakti judgment. I think in Shiv Shakti judgment, it has been clearly held. Yes, interim orders no longer reviewable under section 115. So 115 will not lie, but 227 will lie. Shiv Shakti judgment by 2003, 6 SSC 659.
Citation?
2003, 6 SCC 659. So this is the present position, my lord. Para 31 possibly will make it very clear. Para 31, I'm reading just one paragraph. And possibly this deliberation and discussion is beside the present case. I'm just taking. Para 31 says like this one. In section 2, the expression decree and order have been defined in clause 2 and 14 respectively. It is to be noted that in matters little that the judgment is styled as an order, if in fact it fulfills the conditions of definition under section 2, subsection 2, it is a decree and becomes appealable. Orders that are not appealable are, generally speaking, those which are processual, that is interlocutory or incidental orders regulating proceedings, but not deciding any of the matters of the controversy in the suit. Order 43 deals with appeals from orders. These appeals lie under section 104 of the code. The said section deals with appeals from orders and specifies the orders from which appeals can lie. Subsection 2 of section 104 says that no appeal shall lie from any order passed in appeal under the said section. Section 104 and Order 43 Rule 1 contain a full list of appealable orders. An order which amounts to a decree within section 2, subsection 2 of the CPC naturally doesn't fall within section 104. And the only applicable section is section 96. Clause A to F of section 104 were omitted by Arbitration Act 1940. Section 105 relates to other orders. It inter alia relates to any order that is to appealable as well as non-appealable orders. It is in the nature of a prohibition stipulating that, save as otherwise expressly provided, no appeal shall lie from any order made by a court in exercise of original or appellate jurisdiction, but where a decree is appealed from, any error, defect, or irregularity in any order affecting the decision of the case may be set forth as a ground of objection in the memorandum of appeal. Subsection 2 deals with the case of remand. This section, in fact, contemplates two things: regular appeal from decree and provision relating to grant of objection relating to interim order. Order 43 Rule 1 is an integral part of section 104. A plain reading of section 105 as it stands makes it clear that the stress is on the question whether the order in favor of the party applying for revision would have given finality to the suit or other proceeding. If the answer is yes, then the revision is maintainable. But on the contrary, if the answer is no, then the revision is not maintainable. Therefore, if impugned order is interim in nature and doesn't fall finally decide the lease, the revision will not be maintainable. The legislative intent is crystal clear. Those orders which are interim in nature cannot be subject matter of revision under 115. So if it is not a final order, revision under 115 will not lie. That is why we always file revision under 227. Against an order passed in appeal, filed against an order passed under Order 39 Rule 1 and 2 by the tracker. This is the position. So now, coming to my present case, madam. It is true, my learned friend is correct to the extent that oral submission was made, stateless suit was dismissed, inaction was dismissed. Possibly that is not the, I concede, my lord, that is not the correct procedure. Either there has to be an application under Order 7 Rule 11. Yes. Order 7 Rule 11 D.
Yes.
Order Rule 11 D, this is about rejection of plaint. Order 7 Rule 11 D says where the suit appears from the statement in the plaint to be barred by any law. So here is a case, this falls within the category of Order 7 Rule 11 D. Yes, an application should have been filed under Order 7 Rule 11 D saying that in terms of Section 63 of the 2013 Right to Fair Compensation Act, suit is not maintainable, so please reject the plaint. That ought to have been the correct procedure. Or an application under Order 14, Rule 2, Order 14, Rule 2, my lord. Order 14, Rule 1, Rule 1, 4. Issues arise when a material proposition of fact or law, Lord Space Order 14.
Order 14 rule.
Order 14 says framing of issues. Then if your lordship goes to 2, court to pronounce judgment on all issues, notwithstanding that, 2, my lord, I'm reading, Order 14 Rule 2. Notwithstanding that a case may be disposed of on a preliminary issue, the court shall, subject to the provisions of Substitute 2, pronounce judgment on all issues. Where issues both of law and of fact arise in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only, it may try that issue first if that issue relates to jurisdiction of the court or a bar to suit treated by any law for the timing in course. So normally what is done is, my lord, an application is filed under Order 14 Rule 2 say that kindly frame an issue, a preliminary issue, that the suit is not maintainable. And a preliminary issue is, it can be decided without going to the facts of the case, only on the statement of the plea, because in terms of Section 63, my lord, a suit in respect of any matter, in respect of which a Land Acquisition Act was applied, compensation was paid, will not apply. So here in this case, my lord, injunction petition as well as the suit, both were dismissed on oral submission that is not maintainable. Maybe land court found that it's very easy way of getting rid of one case. And my submission will be, lordship may set aside this order, but there is one aspect, my lord. Ultimately, when the notice was issued, it was issued under Rule 18(2) of the settlement rules for eviction. Against that, my lord, 227 petition will not lie. My learned friend has challenged all this. There should have been 2 separate revision petitions, one challenging the order dismissing the suit, the other challenging the order passed in the injunction petition dismissing the application for temporary injunction also. There should have been 2 separate petitions on that. So far as the eviction notice is concerned, revision under 227 is not maintainable, apparently, my lord. He has challenged that also in here. Now, coming to the other aspect, my lord, here is the case where, my lord, it is not 2013 Act, but the notification of 2022. Notification of 2000, because the state has filed a written statement and taking a specific plea. I'm just pointing out one paragraph for the purpose of convenience of this court. Here also goes to page 83.
Yes.
Now, yes, 83, para 13, my lord. That in reply to contents of para 6 of the plain answer and defendant number 2 basically submit that district level land purchase committee headed by defendant number 2 is required to issue general notice to the landowners regarding proposed purchase of the land. However, it is submitted that plaintiff is a tenant under defendant number 1 and hence cannot claim an easement right against his landlord, that is defendant number 1, for which plaintiff cannot be considered as person interested. This statement of fact is factually or legally not correct, although it has been mentioned in our documents. That is not the correct position of law, madam. Now, Lordship may kindly see what I am trying to point out is page 85, para 18. Para 18, second part, my lord. Starting with the words, it is pertinent to mention, if your lordship is concerned, that as a result of filing of the instant petition, the construction work near the suit premises has been hampered badly and the very area of the road has been more accident prone. And recently on 31st of December 2024, accident took place near the area and also the project of Assam government of the improvement of upgradation of major district road for the greater interest of the public has become stagnant. And what has happened, when there is an accident prone area, the land was acquired not under 2013 Act, but under this 2022 notification, which provides for direct purchase through negotiation. Your lordship is aware of that. if your lordship goes to the authority has to purchase it through negotiation with the owner of the land. And in this case, at various stages, my lord, the negotiation took place, owner came, then if your lordship goes to Roman 3, 4, 5, my lord, two says a district level purchase committee, DLLPC, under the chairmanship of deputy commissioner is to be constituted for direct purchase of land as well as fixation of market value, etc. Step 3 says concerns revenue circle officer and the representative of the requisitioning department will conduct joint inspection of the requisite land. The area of land and immovable properties attached to it will be measured and mapped. Step 4, general notice will be issued to district level purchase committee to the landowners regarding proposed purchase of the land. Step 5, a list may be prepared for those landowners who may agree to sell the land after ascertaining the actual owner of the land if necessary by conducting field inquiry, etc. Step 6 says the list shall be published inviting objections, if any, regarding interest and ownership of the land, etc. For receiving objections from the landowners, a waiting period of 1 month shall be given. Then step 7, DLLPC will prepare the valuation of land and assets. The requiring department may also define a few typical immovable assets of different categories and fix the guidance price to appropriate authority. This price of the assets attached to the land may be calculated on pro rata basis on typical immovable assets mentioned above. So, at various stages, objections were invited. He never came forward. He is a tenant. Or he has annexed the plane. Lord may kindly see the plane at page 7. His grievances against his landlord. And grievance arises from the agreement between the parties. Lord may kindly see page 69. Part of this plane, page 69, a little above para 4. In accordance with the same terms and conditions, out of 4,50,000, only 2,49,000, he has made a mention in this above Roman 5. After 6 months, second party shall pay an amount of his so and so, etc., etc. Now, in accordance with the same terms and conditions, out of 4,50,000, only 2,49,500 only been adjusted in rent, and now the amount of rupees 2,05,000 is due to the plaintiff. Now the plaintiff has come to know that PWD Assam has undertaken extension of road of Hemchandra Goswami Path passing through Golaghat town, and according to the land of ticket number 1 situated at ward number so and so, holding number so and so, was acquired by the land acquisition authority. That it is noteworthy to mention herein that defendant number 1 had already received an amount of rupees 3,12,000 as compensation for her acquired land and 9,25,000 for the state building, and the same is learned from a reliable source. This is his grievance. Now, his prayer is at page 72. He is a tenant man. Admitted. Prayer number 1 is for a decree of declaration of right, title, and interest over the suit premises. He is a tenant, admittedly. He says, his case is that I have constructed the tenanted premises, and the agreement between the parties is the cost of construction will be recovered by adjusting against the monthly rent. And that way, adjustment has taken place to the extent of 2,00,000, and remaining 2 lakhs is left. So far as state is concerned, it is his admitted case that state has given the entire compensation money to the landowner. Naturally, my lord, we have to give it to the landowner. Tenant is not entirely, he is not a righty tenant that 1/4 or 1/3 he will get. In that case, the state had the authority to pay directly the money to their tenant, right? But here is a landlord-tenant, a tenancy agreement is there between landlord and tenant. For that, state is not obliged to pay anything because he doesn't know. State has got no record that a tenant has executed an agreement, tenant is entitled to something from the landlord. It is between landlord and tenant. His grievances against the landlord, he has unnecessarily made state a party. And now I'll show my lord. Lordship, you kindly see, he is praying for declaration of right title interest that he is not entitled. My learned friend will agree. He is a tenant. Second place for direction to stop demolition. That also is not entitled because it is not his land. House is also not his. He has constructed the house with the agreement that I'll make the construction, spend the money, but I'll adjust against the rent, meaning thereby, ultimately the cost of construction is also to be borne by the landlord. And landlord is the owner. Compensation for demolition of that house also will go to the owner. And now, in between, if something has happened for which you could not adjust the remaining part of the cost of construction, that is 2 lakhs, then you have to recover from your landlord. That is the whole case, my lord. And now, Lordship, can you see one more thing? Page 60, sorry, page 67. Defendant number 1 is the landlord. Defendant number 2 is the state of Assam represented by Deputy Commissioner. I know your Lordship is aware in terms of section 7980. It is the secretary of the government state who can represent the state. Deputy Commissioner cannot. So that way suit is otherwise also not maintainable against the state. So that way, to that extent, learned trial court thought that from all sides, this suit is not maintainable. And section 63 is very clear, your Lordship is aware, no suit is maintainable. Any person interested who has not accepted the award, 63, no civil court shall have jurisdiction to entertain any dispute related to land acquisition in respect of which the collector or the authority is empowered. So suit is not maintainable, that is for sure. Only thing is the trial court has adopted a very shortcut procedure, which in my humble submission is not correct. Either Order 7 Rule 11D or Order 14 Rule 2. But today or tomorrow, my learned friends suit will go.
No.
Number 1. Number 2, my lord, now in order to be entitled to get a injunction against the state, they will have to not only establish prima facie case, balance of convenience, irreparable loss and injury, but there is a fourth thing now, your lordship is aware, public interest. Your lordship is absolutely correct. So public interest is so overwhelming in this case. Public interest is very important, not only for widening, to protect people. Because it's an accident prone area and a specific date has been given when last accident took place. And what is the right of the petitioner before lordship? Right is to get back that money from his landlord. So far as state is concerned, entire compensation money is duly paid. And even in a case of a land acquisition, my lord, even the owner doesn't have any right to prevent acquisition and use of the land by the acquiring authority. He is entitled only to compensation. The lordship is aware, under the old act, also under the new act, the only objection even the landowner can raise is that, see, you are acquiring the land not for a public purpose. Other than this, he cannot raise any objection. He cannot say that I want to retain my land. He cannot say that you are paying less compensation, so I will not give my land. He can always go for a reference under section 18 under the old act. And I think it is 30 something under the new act for reference, for enhancement. It is for the landlord, not for the tenant. Tenant has got no right whatsoever, my lord. This suit is not maintainable from any corner. So in that way, the matter, my submission will be, lordship may set aside this order. Technically, this order is not correct. I concede to that. Technically, this order by one line that suit is not maintainable, oral submission. Procedurally, under the CPC, either Order 14 Rule 2 or Order 7 Rule 11T. Let the matter go back. Appropriate application will be filed by us, but till then, this injunction order should not, the stay order should not continue. And so far as that notice is concerned,
Stay order?
passed by the Supreme Court.
Yeah.
That should go.
Okay.
That is my.
My lord.
This
May I get chance, my lord?
Public interest.
Let him complete.
Achha.
Yeah.
This is
I
against
think
public
it's
interest.
ended, I think.
I'm-
Remaining
Yes.
just to we have to learn so many things from him. Anyhow, we are learning. First and foremost thing, my lord.
learning.
First and foremost thing, my lord. This petition Civil division petition, I will also be in doubt. That is why I put in on 2 to 7, not on 115. Second point, for your lordship, I want to know from my learned senior, whether they are taking into consideration of right to price compensation act or not. If act is taken, we have to go by that. I'll go by that way. Because my learned senior is telling this act is not applicable. One hand. Another is telling you a rejection my petition on the basis of that. We want to know, I have both the way argument. I may be wrong. Hear me, Lord. Hear me, Lord. If I say, see, this one is a lot of my, that is why I want to get clear from him, my Lord. Then only I have to argue, I can argue the matter. Because hear me, Lord, only we come before your lordship, whenever we come to High Court, not only for one case, my Lord, we come for learning the things. Only it is a learning also. We have to learn from seniors, from your lordships. We may be wrong because that is why now, if my learned senior is taking that, okay, this act will be followed, I will argue that manner. Or if my learned friend say right to fair compensation is not applicable, then that way another manner I will argue. Because both the way you cannot take. WS, you are saying that this act is not applicable for you, not at all applicable. But you are dismissing my petition against you, taking chance of 63. That is of this act. How you can take both? You cannot take. Now, if it is assumed now, both the way now I will argue, if my learned senior is clearly saying, as per land acquisition through direct purchase, way of negotiation, settlement, or public purpose of all department in the state of Assam, that is of amendment up to 3020, that is a 7th March, that is a notification. Lordship, my learned senior has shown, have studied. Here you will see, here provision, because this act I am also dealing with for a long time because NSI, NSID, fully it is required. Here you will say, whenever Assam Mala particularly, this act is original basis, right to fair compensation act. But what happened? Why this act is applicable? Because if we go by procedure, it will take long time. That is why to shorten that time, direct negotiation, even my lord, it is clearly written. If direct purchase, if someone is not agree with direct purchase, they have to go by procedure of that particular act. Suppose I'm not agreeing, my land is going, I'm not agreeing on this procedure. Now I'm not on that. Here, my lord, my learned friend has read up to, that is Porota, that is Porota up to step 7 years read. Now I'll read further. But read further. State will go, step 12, this one, he has read 7, 8, 9, 10, 11. I'm not going on that. 12 it is saying, my lord. Lordship, I have this book. Lordship, here Lordship, step 12. The settlement reached in the negotiation shall be recorded as agreement through Form C and Form D for landowners and for interested person other than the landowners, if any, respectively, other than landowners. An undertaking in Form B may be signed by the landowners declaring that they will not claim for payment higher compensation in any court of law or any other forum, and shall be abide by the sale agreement finalized in the DLLPC. The landowners and other interested person have to provide their electronic transfer details through electronic transfer mandate form. Now, my lord, here it is one Form D. What Form D says, my lord? Because clearly says, what Form D says, lordship? Form D. Lordship got it? Form D. Form C for landowners. Form D, agreement with person interested other than landowners. Here I am the person interested. Now I will come whether I am person interested or no as per that act. Lordship, there is a holding number. I am holding that. As per Act 2000, Act on the I mean, holding, Lordship will get. Now, if we follow the, okay, rightly this one is cancelled. I think though they're saying this act is not applicable, I am thinking that it is applicable. In that case, harm been protected. Lordship, definition and holding, by holding number. Holding means the total land held by person, an owner, occupant, or tenant, or otherwise. That is clearly mentioned. Now holding the land. Now, my lord, I will go to X, definition X. Person interested means, Lordship got it? Lordship, I will go by stateway. Person interested when affecting land. Decision means it is in being potential later. All persons claiming this X is saying all persons interested in compensation, all persons claiming an interest in compensation to be made on account of the acquisition of land under this act. Next, the scheduled tribe schedule is not applicable. Person interested is when affecting the land. Person having tenancy rights over the relevant state laws, including sharecroppers, croppers by whoever name is. Tenant also person interested. It is defined in the addition section 3X of this act, my lord. I am a person interested. I am person interested. What happened? This person interested, here respondent number 2 has given me authority. First is given me, lord, when I have raised the question. When I have raised the question, okay, my tenancy is not given because they would, actual procedure is that, my lord, as per my knowledge, whenever it is land to be acquired, particular land is to be acquired, we have to, that authorities has to, revenue authority, the acquiring agency has to see who are the tenants or who are occupying. We have to go to notice also. Next, second, they have, that is why on my basis of complaint, they have given 2 notices to both of us. One notice, I appeared. Second notice, she did not appear. She appeared. Thereafter, even court below, I'll come to 17/2/2004. Yeah. Trial court, while going to dispose of the injunction petition, before, though it is a date was fixed for 5/3/2005, because they have filed one application under specific relief amended at 2000 under basis of section 20. That was to be heard because whatever say, whatever my learned senior is saying, okay, this is as per this section, we do not have right, state has power to acquire the land. And that basis application hearing was conducted. And ultimately it was said, observed on 17/2/2000, I'll come to that, my lord, 17/2/2025, before date of dismissal earlier date. This court, the trial court has clearly held person, petitioner or plaintiff having interest upon this. Clearly says, he observed, this is judicial order. You cannot now, he or learned court below, he suddenly cannot twist. Only then thereafter, this is clearly certain. That apart, my lord, that apart. If I'm not interested person, my lord, I'm not interested person. Say, I'm assuming that it is, I'm not interested person, I'm stranger. I'm not entitled to anything. Why 11th notice was required? Why 11/3/2025 is required? They would have immediate demolished. They know because I'm person interested. I'm having holding number. I am paying electricity up to 2 because I have obtained illegal trade license. Everything they know each and everything. They were in this one.
Mr. Porua,
My lord.
you argue all these points before the trial court?
But my one submission is given, Lord. I'll argue only why I'm saying all these things, my lord. I'm very happy. This learned senior means always maintaining seniority. That's why I'm always grateful because we have learned from him. It is not that. Well, always civil matters, I ask him, what is to be done, sir? Not that. But one question why my anxiety is this one, my lord. My anxiety only this one. Let trial court, he already suggested as per 14(2) or another provision he has shown, it is clearly his If another person would have been, he has not shown this provision, he has at least shown, I'm happy. I would, it was my duty to show to your lordship, but he has shown anyhow. I'm lucky enough. But I may be protected till decision of that. Suppose, my lord,
Yes, Mr. Mazumdar.
till that,
Let it
1 day,
till,
2 day, 3
But
day,
this,
1
this
week.
protection is not entitled.
No, not
For this-
entitled, but
this protection, because this protection will go against the order passed by this notice. Against notice, this revision under 227 will not lie. Lordship cannot pass any order invoking 227.
but here question is coming, my lord.
And
If
so far,
my suit
so far as
goes,
injunction petition is concerned, it is yet to be heard. Let the trial court take the decision.
yes,
But till then, nothing can be passed.
till then, my lord.
But
Otherwise, but
one submission can I make? May I make? Assuming that he is ultimately adjudged to be a interested person, because tenancy right. Although this by this definition of interested person, tenancy doesn't mean the landlord-tenant tenancy. It means that a riot, non-applicable tenant, etc., who have a share in the land, because they become some tenants become non-applicable after 30 days. Occupancy tenant. Anyway, my lord, this court is not deciding all
no,
these things.
here,
My submission before lordship is, assuming that he is ultimately found to be interested person, then his claim only will be to get compensation. He cannot prevent the state from using the land after the land is purchased through direct purchase. And one particular thing I would like to comment from this notification, 63 will anyway come.
yes, judgment.
63 will anyway come because, my lord, if your lordship goes to clause 5, direct purchase method, is got, my lord.
Clause 5 of the notification?
Yes, my lord. The direct purchase method the direct purchase method will be all encompassing, inclusive of all compensation and resettlement and rehabilitation benefits as specified in the Act of 2013. So it is not something foreign to 2013 Act, right to care company. By taking into considering the various provisions and to shorten the procedure
Yes.
of acquiring land, this has been adopted. So 2013 Act remains, because compensation also is to be granted in terms of 2013 Act matter. This notification itself changes.
If so,
Roman 9 says, step 9, direct purchase price shall be higher on compensation calculated as per the provisions of section 26 to 30 and first schedule of the 2013 Act. So it is not that 2013 Act has not been taken into consideration while framing this notification. This notification is to grant compensation even higher than 2013 Act and taking into consideration all the requirements of law under the 2013 Act, so that the person whose land is acquired is not deprived of his right to care. And then what will kindly see this above 4, Roman 17, step 17. In the event of any owner refusing to sell the land or any of the owners having objected or are not interested with the direct purchase through negotiation, the respective land may be acquired through land acquisition process of the 2013 Act.
that's submitted.
So in any way, 2013 Act has been followed, but in a direct purchase scheme. Now under the Act or under this notification, if the land is acquired for a public purpose, the owner of the land or anybody interested, let us assume for the timing that this tenant is also an interested person. His claim only will remain to get the compensation, but not the land. So state cannot be prevented from using the land after it has been purchased. An entire amount is paid. It is for public purpose, not for any private purpose. So even if his suit is ultimately found to be maintainable on the ground that he is adjudged to be an interested person, his claim will be, and in this case, we have already paid the money to the landlord. From the landlady, he will get a decree. But the state can be prevented from using the land for a public purpose for which it has been purchased.
Now, my lord, notice. We'll go by notice now.
And admittedly, full payment compensation has been paid to me, to the landlady.
Here,
So that being the position, my lord, in the construction should not be stopped by any holding order, that the trial could proceed in accordance with you.
here, Lordship, notice how it has notice been originated. I'll let judge now.
And
11
against the notice, my lord, this 227 is not maintainable.
Yeah,
that
that's
is
correct. That's যেহেতু অভিযোগ আবেদন জিলা আয়ুক্ত গোলাঘাট মহোদয় নিৰ্দেশ মিস জে 72/7 টাইলছুট so দেৱানী ন্যায়াধীশ জ্যেষ্ঠ বিভাগ ভিত্তিত মৌকা মৌজা গোলাঘাট চহৰৰ 2548 পিয়াদী পট্টা নম্বৰ দাগ নামাৰে যিসকল বিবাদ অন্তত দেখা যায় আপুনি উক্ত as soon as this suit was dismissed, the conduct is to be seen conduct. Till that, you would have power, full power. My learned friend is having senior. We also know what prevented you to do this or this or all thing. Why you have waited, contested the case. Now, why this after dismissal it is been dismissed? What is the conduct is to be seen? You have power. You have power. Very beginning I have said, why this notice has been given? Because of this dismissal. Ultimately, they tried by any means they have dismissed suit against them thereafter. Even I'll go by this one, my lord, that earlier if I go work for this one 17 injunction what is it? 17 it is the order to put it. Here, my lord, only it is I'm giving your lordship because I'm under 227, not exactly this one. I may be wrong due to approaching or due to fault of counsel. Due to my fault, I would have raised, but client should not suffer. Why the suffer also is to be seen. If it is demolished totally, how will they will assess my decision? Because if I go by law, my lord, today if you hearing permits, I'll show.
No. The compensation of the land and the.
No. I share
house
my
of the
shares.
thereof has already been assessed. And
No, assessed means
compensation was
my
paid.
soap is not assessed, my lord. My soap is not assessed. That is why how much I will get not ascertain. They have not at all come to me. They have not entered my soap. That is the problem, my lord. That is why I'm saying we are insisting very beginning to deputy commissioner or district commissioner that you assess my soaps, whatever I should suppose, because landlady is not willing to
That
give
is
anything.
an agreement between you and the landlord.
That's correct, my lord. But I'm an interested person. I'm an interested person. I follow the whole rules and regulations. By being an interested person, here I'll show the judgment. How interested person are getting this one. I have lot many judgments in this regard.
Mr. Borua,
My lord.
there is one provision in the Specific Relief Act that in respect of this public projects, the injunction cannot be granted.
Yes, that is section 20. Even Supreme Court has said, my lord. Supreme Court has reached judgment is there. Public interest there. But here the question is not coming. Road has already been constructed. Road has already been photographed, says my lord. Only some portion is left, that is for drainage. Only my question is this one. At least before demolishing, if been assessed by the authority, so that I can, because until and unless it has been assessed.
Let the trial court consider all these things.
All this, that is I'm telling.
Lordship
But
may
if
submit back to the trial
it is
court.
demolished, nothing survives, my lord.
My
That is why I'm praying for
Yes,
some days.
Even if it is demolished, everything will survive because his claim is not to get back the land. His claim is to get the money.
Money.
Even
But
if
how will
this is
assess, my lord?
decided after 2 years, he will get the money on.
That is only I will get it. Definitely I'll get it. Because we go for, there is a very saying that how person interested getting. My problem is this one, my lord.
Mr. Borua, the dispute is between you and the landlord.
Yes.
But here state is involved. As per act, this is state is involved, my lord. I'll bring to this one. If your lordship permit for hearing, I'll bring all documents. How person interested? Even, my lord, being person interested, we are national highway been affected because person interested. Person interested. We have now my learned feeling that tenant means how he's saying this act nothing defines. Other act it may be defining, but here tenant, what is tenant? Nothing defined. We are also arguing all this matter. I'll show this, but I am not that, and because a learned friend is very he's kind enough to set the return. But only suppose, my lord, if waiting for so many days, lordship pass an order with this matter one only chance should be given. One chance should be given because everything, he will give one application, we'll file objection. If satisfied or not, that will, everything will go till date, my lord, or 10 days, 15 days, nothing will happen because due to suit goes.
Okay, Mr. Mazumdar, let it be for 1 week. This order is for only one.
My only anxiety is
No, that is there. Your
my
anxiety is
anxiety
there.
is twofold, my lord. One, it is not a case where wrongly the injunction has been refused. In that case, your lordship can say that no, I am granting an injunction for 7. It's a case where his injunction petition was dismissed on a technical ground. On merit, nothing was refused. So it will go back for consideration on merit.
Yes.
As far as that notice is concerned, my lord, my submission is very clear. It is not his case that I want to retain the land. His case is to get the money. Money he will get today also if he is entitled, or after 2 years also he will get it. But land he is not going to get in any case.
No, I will not get it.
So why should we prevent the state from going ahead with the construction of the road only on the ground that he wants to retain the land? Because I have a fear that he may not pay the money. State will not run away, my lord, if the state has got any responsibility, liability. And so far as liability is concerned, admitted position is we have paid the full amount to the landlady. The dispute is between him and the landlady. And my instruction last evening to my counsel is that he had an interaction with the ADC. ADC said at one stage we called both the persons. Notices he has annexed the notice on 4th of November 2020. Both of them came. Although he claimed that he constructed the house, landlady says no. Only internal construction for his shop he made some development. For that,
is also not been
for
said.
that, the lady said we will pay the amount. It is his averment in the petition that lady said she will pay, but she did not pay. So it's a purely dispute between two private person, but he is now preventing the construction of the house.
No.
That your lordship will not.
Here,
in
my,
this case, my lord, I will not.
but here, my lord,
It
I
will
will come.
be exceeding the power because under 227, your lordship possibly will not have power to interfere with it.
No, that's correct. But how notices come, my lord? Cause of action. How it has been arisen? Because dismissal of order, notice itself clearly says.
Parties, if I had
Notice
appeared for a
itself
private
clearly
party,
says.
I
due
would
to
have considered for 7 days. But here it is a public interest.
Here, my lord.
Accident prone area. Today or tomorrow, my lord, even neither the trial court nor the summary court will prevent construction of the road. It is only determination of compensation, if any, he is entitled.
But in this regard.
And that too, he will have to get it from the landlady, not from us. From
Here-
our side, we have got nothing.
Here, my lord, only
So
my
our
say.
construction should not be stopped.
My saying is this one. This notice has been, simple notice would have been this one. But they taking the chance of dismissal of suit, they have clearly mentioned.
My
Due
learned
to
friend-
dismissal of your suit, this is a injunction
lord-
petition, this notice is served.
My-
Is it not, is it conduct of the parties not to be seen?
My
Because they clearly said that due to your dismissal of the petition against defendant, this one, these two words would have been not there, I would have not on that point. But they themselves said they are taking chance. Will your lordship, for ends of justice, lordship before you, I am lordship under 227, or lordship maybe may not be 227. As all whole, I am before your lordship. I am in, no, am I not entitled for 7 days? Am I not entitled for 7 days?
Which power, my
Here,
lord,
my lord,
227 power he cannot invoke against that notice.
is correct. But your notice, you have taken this one notice.
227
You have said
power is
this
not
one.
available.
In WS, they have said that this act is not applicable. How it can be? It is a contradictory. I may be protected, my lord. I am leaving the lordship. 7 days. I think never will not fall down, my lord.
It will be going.
Oh, Mr. Mazumdar, it appears from the photograph that
Road is constructed, my lord.
road is already constructed.
Constructed. Ase color photo দিছো মই lordship দেখাই দিম color খনত ভাল
Hey, Lordship will remove the interim order, they will continue with the construction. But my land friend is not saying that I am entitled to the land or building. I want money. Lordship will determine after the trial court says, Lordship will determine whether he has got his money or not. But so far as land is concerned, he is not entitled to it. It is not his case that I am entitled to get back the land. So why should we stop the construction of the road, man? And in an accident prone area. And that too in a case where he is invoking Article 227 to challenge an order passed by the circle officer, which is not maintainable.
No, let us do one thing.
My lord,
We'll not pass any order,
my lord,
but you instruct the ADC
my lord.
that till the disposal of this petition by the trial court, this notice may not be given effect. Will not pass any order.
My lord,
to that effect.
difficulty is, my lord, all right, but for 7 days we'll not do anything.
7 days.
My lord. Lordship need to pass an order, I'll instruct them not to do anything for 7 days.
Okay, no,
Fine.
I will not pass any order
My
to
lord,
that effect.
my lord.
Okay.
I'll oblige you.
Lordship, dispose it off.
Okay.
Well.
About 13.